My lord, with your lordship's leave, my lord,
Item number 3.
Item number 3, Lordship, I am for the petitioner. Lordship, this is first time contempt.
Please wait. So actually, you are the applicant.
Item 3, my lord.
Nobody is here.
Later.
Please wait for some time. This matter is appearing. Yes.
Lordship, this is first time contempt, Lordship.
Where is that order?
Lordship.
Order.
Order, Lordship, 12 September 2025, page 24, annexure P1 of the contempt application.
Notice issue. This matter is appearing under the heading to be mentioned. No, application. Application. Issue notice. 4 weeks. Next.
I am for the alleged consumer. Then the apology for compliance. But it is complied with.
Lordship, the affidavit of service has been made as per last order.
Dear Lordship's order dated 2nd of September 2025. There was a direction is compliance report to এই পাতাটা কেন এভিডেভিট অফ কমপ্লায়েন্স করা দিচ্ছিল এই জিনিসটা বলেছো can you take full Lordship's order? Each and every part has been complied with. Your Lordship's directed internal page from the internal page 2. There was a direction for preparation of sketch map. I have done so. There was a direction for issue notice regarding whether there is any part of violation of section 23. We have issued a notice. The private respondent number 7 appeared. If you Lordship kindly take page 10 of my report. Upon notice, we asked the private respondent to provide the sanction plan issued or not. He did not. So we have to hold that yes, there is a violation of construction of building. Accordingly, we took a decision, and it has been forwarded to the SDO. Internal page 11, last page, copy already forwarded to the subdivisional officer for taking appropriate step. Pradhan internal page 11, second paragraph. So Pradhan asks the respondent number 7 to produce the sanction plan for construction of a building such and such in a situation in a district such and such. Respondent number 7 failed to produce any sanction plan of the building situated on the aforesaid land in question. So therefore, appropriate step is to be taken now by SD in terms of 23(6). So let it be disposed of. Contempt petition may be dropped. And my lord, kindly take the case map itself. I have annexed at page 5. And on the basis of that, we have issued a notice, page 7, and first page also.
But shall I request a demolition for the illegal construction?
That cannot be done by Pradhan. It should be taken up by the SDO.
But I am so grateful. Your Lordship is not part of that order itself. So therefore, it can be dropped. Let the authority can do this in terms of this communication. Page 11, bottom. SDO করবে এটা মনে হয় I'm so
After-
grateful to you, Lordship.
Affidavit of service filed on behalf of the petition is taken on record. Mr. Vishwarup বিশ্বাস, learned advocate, appearing for the alleged contemner, submits that the order of this court dated 2nd September 2025 passed in
Report copy দেয়নি
the
তোমাকে?
writ petition
copy দিয়ে দাও।
has been complied with.
I am handing over the client কে দেওয়া আছে।
Moreover, the finding of the Pradhan has already been forwarded to the subdivisional officer for taking steps under section 23 of the West Bengal Panchayat Act 1973. He files copy of the order passed by the alleged contemner as well as along with copy of notices and sketch map, which is taken on record, copy served.
I have served and I have served also the client itself. Petitioner.
Learned advocate for the applicant concedes to the aforesaid submissions. In view of the above, the contempt application being CPAN 301 of 2026 stands disposed of.
I'm so grateful to Lordship. Man.
Yes.
Get.
Application is to be mentioned. Application. কোথায় মিস্টার জাহান কোথায়? তিনটা করে দেখো মিস্টার জাহান, what is the application?
Scan mano that was filed by the private respondents in connection with the main writ petition for modification of the order.
That cannot be. That is served upon you.
That was served upon us in the month of September 2025.
Oh, nobody is moving that application.
I mean, pursuant to this court's order, the parent order, my lord, alleging violation.
আরেকবার দিন না রেকর্ড। ক্যান নেই, তাহলে এটা আসুক না, নোটিশ বা সার্ভিস করে। Department is directed to place scan 1 of 2025. Let the notice be served. See,
Yeah.
can is not there. I am directing the department to place the can. Thereafter we'll see.
Madam, I am for the petition.
My lord, I am for the state.
My lord, this is the affidavit of service.
What is the prayer?
My lord, this writ petition has been filed, my lord, against the inaction on the part of the respondent authorities to grant HR, HRA, my lord, house rent allowance. My lord, both the spouses are living separately because of their different place of work, my lord. And I am the petitioner is the wife, and she is working at a primary school at Memory, my lord. And husband is working, is posted in Bakuda, my lord, under WBSETCL.
That is also under state. That is state.
My lord, my lord.
Okay.
For the state, WBSETCL is also under the state, my lord. Electricity department. My lord, the ACDCL has become now ACTCL,
Okay.
Transmission Limited, my lord. My lord, the distance between both the station is, my lord, above like, my lord, 144 kilometers. This is a non-commutable distance, my lord. Husband cannot go daily from Memory to Bakuda, my lord. Since
That
2013,
is, what is the distance that is given? 150.
144, my lord. Presently 144
As
kilometers.
per rule, it is 150.
My lord, as per rule, my lord, if it is above 50 and within 150, my lord, and that if the distance is non-commutable, my lord, then the authority can grant full HRA, my lord.
My lord, we
My lord,
had
this
the
is the
instruct-
notification.
Lord, kindly go through with
Give a copy to him. Get a copy. In case.
My lord, C and D, my lord. But I
Is it
mark
not commuted?
little bit mark, my lord.
HR as per rule with approval of this one may be admitted. Leave separately.
But as per instruction, they are under same.
As per instruction, my lord, I am also, my lord, eligible.
As per ROPA 2009. Interim
And
account
let my
6,000
representation be
per-
considered and disposed
month.
of.
per month. As per the petition spouse was drawing. So the petition is not intended from 2019 to December 19. Para 2 of the report. From January 13 to 19, they were living together.
No, my lord. No, my lord, my lord. I have annexed everything, my lord. My lord, since 2013, he was on Bahrampur, my lord. Thereafter, my lord, in 2017, since 17, he has been transferred from Bahrampur to Vidyut Bhavan Salt Lake, my lord. And thereafter, from Vidyut Bhavan Salt Lake, in 2025, he has transferred to Bakuda, my lord.
And this petitioner was all along at Memari.
All along on memory, my lord.
Where is that order of transfer
My lord,
of the husband?
my lord, my lord, 31, page number 31 to 35, my lord. Transfer order.
31. January 31st, in person the officer did.
My lord,
But
31, thereafter 32. And 33, my lord, Bakuda.
January, direction report to Barhampur. So till January you were in Bardhaman, which is memory is also under Bardhaman.
My lord,
31st January 2023, afternoon you have been released.
my lord, 2013.
13. Afternoon you have been released.
My lord,
So till January 13 you were in Bardhaman.
my lord.
Memory also falls under Bardhaman.
Memory also comes under Bardhaman, my lord.
So 13 to from February you can claim your
My lord,
February 2013.
2013.
Now he goes to Bahrampur. What is
Bahrampur.
it? Bahrampur to Kolkata.
Bahrampur to Kolkata is page number 32, my lord.
His name is. What is the name of the husband?
And at Onubhode,
Onubhu De.
serial number 1, my lord.
Bahrampur. Future place of engineering department, that is in Kolkata.
Kolkata, my lord.
So from February 2017 till he has been
My lord,
transferred.
25.
Still now he is in Kolkata.
No, my lord, he is in Bakuda in 20. My lord, page number, kindly come to page number 33, my lord.
33 afternoon, yes, goes to Bakuda.
Bakuda.
Okay. So you're entitled from February 2013.
13, my lord.
Next, ROPA only revised limit of HR became 12,000. In January 20 petition achieving eligible for HR amount. Says that May 2025 you are drawing the HRA.
My lord, since that at the not at the rate of 12%, my lord, per month, my lord. Because my lord, I have they have given I am entitled to get full HRA, my lord.
But then if 4366 is not the full HRA.
No, my lord.
Which is the full HRA then?
My lord, full HRA will be, my lord, 7,000 something, my lord. That has not yet been calculated, my lord. 7,000 something, my lord. That would be.
There are few allegations against you that you have not submitted the
My lord, I have
HRA declaration.
My lord, I have submitted all the declaration through that has to be submitted by the headmaster, managing committee, and headmaster, my lord. I have submitted, my lord, but they have not forwarded, my lord. Because I don't have any other option, my lord.
Yes, was When did you make your representation? 15 September.
My lord, 49, my lord, page number. Yeah. 24th September, my lord.
24th September.
My lord. In this July also, my lord, I have submitted the declaration again, my lord. Because two declaration has to be submitted in the month of January and in the month of July, my lord.
See, you comply column number 9 of the report. They say that some of the documents have not been annexed, for which they cannot take the decision in respect of your representation.
My lord,
You
let the
see the document.
I will submit, my lord. My lord, let this writ petition be taken into as my final representation, my lord. Because I have
Since-
annexed
no.
everything into this writ petition and
Para-
all these documents has been submitted.
Para 5, there is a representation which has been taken cognizance by the authority, but they say that some of the documents have not been annexed.
My lord, that has to be communicated to me, my lord.
You have not received any letter.
No, my lord, no. Nothing.
Affidavit of service filed on behalf of the petitioner is taken on record. The report filed by the District Inspector of Schools P. Purbo Bardhaman, dated 22nd July 2026, is also taken on record. Copy served. By the present writ petition, the petitioner seeks for disbursement of full HRA which seeks direction upon the respondent authorities, particularly respondent number 3. Three or 4. Who will issue the HRA?
No.
Kiradin. To grant full HRA at the rate of 12% per month. Upon consideration of representation of the petitioner dated 24th September 2025. The petitioner contains that she is an assistant teacher posted at Krishnapur Rambollo Pre-Primary School within bracket government aided since 3rd May 2012 under District Primary School Council Purbo Bardhaman. Memory Circle. Memory Circle. The husband of the petitioner, namely Onubho De, is an employee of WBACTCL and currently posted at Bankura. The petitioner's husband is staying more than 100 kilometers away from her present place of posting since January 2013.
More than 100. I am annexed the rail ticket also, my lord.
The present distance is 140.
44, my lord, as per rail station, my lord. From
The present distance between the place of posting of the petitioner and her husband is about 144 kilometers. As per the existing rules, the petitioner is entitled to full HRA. This has been stopped since
2013,
January,
my lord, February.
The HRA of the petitioner has been stopped by the respondent authorities since February 2013. On 24th September 2025, the petitioner made a representation before the authority concerned for grant of full HRA. However, the same has not been considered as yet, hence this writ petition.
Fine.
Mr. Tirthankar Dhali, learned advocate appearing for the petitioner, submits that as per the memorandum number 955-AC within bracket law/ACL/5S-1221/09 dated 27 July 2021, issued by the School Education Department, Government of West Bengal. Clause 2C and D. The petitioner is entitled to full HRA as the distance between her place of posting and that of her spouse is non-commutable. He seeks that the matter be relegated to the appropriate authority to take a decision on the representation of the petitioner dated 24 September 2025. On the contrary, so-and-so learned advocate appearing for the state respondent submits that the petitioner did not submit mandatory HRA declaration as per GO number 97-AC within bracket B/M-24/2001 dated 7th March 2001 of the School Education Department. Repeated reminders were issued to the petitioner to submit such declaration. However, she failed to comply the same, which has resulted in stopping of the HRA. However, if the matter is sent to the appropriate authority, the same will be considered in accordance with law. Admittedly, the petitioner made a representation before the authority. Where is that representation?
Page 48, my lord.
Seeking for grant of full HRA on 24th September 2025. The report of the state also shows that the same is pending before the District Inspector of Schools P. Purbo Bardhaman. The report also records that some of the documents are to be submitted before the authority for further consideration. In view of the above, the respondent number, District Inspector of Schools,
Respondent number 4, my lord.
respondent number 4, District Inspector of Schools, school, Primary Education, Purbo Bardhaman, is directed to consider the representation of the petitioner and dispose of the same in accordance with law within a period of upon notice to the petitioner within a period of 6 weeks from date of communication of this order. Subject to production of all relevant documents.
My lord, kindly ask the DI to notify me what are the documents is more required, my lord. Because I have submitted the declaration form, my lord, with all documents, my lord.
Okay. If any document is required to be submitted, same shall be notified to the petitioner. And upon such notification, the petitioner shall comply in accordingly. Learned advocate for the petition. Reason order shall be communicated to the petitioner within a week of passing thereof. Learned advocate for the petition is added to communicate this order, disposed of. School. Even school.
My lord, the memorandum, year of the memorandum is 11, my lord, 2011.
Huh?
My lord, your lordship has directed 2021, my lord.
Memo number date টা কত বললো? 27 November
2011, my lord.
21 বলেছে? দেখে আমি 11 করে দেব। হ্যাঁ, ওইখানে এটা দেখো তো, এই যে রিপোর্টটা দিয়েছে আছে, র্যাঙ্কটা দেখে নেবে। স্কুলস ঠিকই আছে, এসব ঠিক আছে। ডিসপোজ অফ।
Yes, my lord. My lord, I am for the petitioner, my lord. I am praying for withdraw the writ petition. I pray liberty to file fresh, my lord.
Why?
There are some mistake, my lord. Date of joining, date of retirement is not there, my lord. And also,
Learned advocate for the petitioner seeks to withdraw this writ petition with a, since the same has some typographical errors. Same has certain typographical errors with liberty to file afresh. এরকম করে দিন তো, যে submit sir, the writ petition has some typographical error. He seeks to withdraw the writ petition with liberty to file afresh. In view of the above, the writ petition stands dismissed as withdrawn with liberty to file afresh. Interim order.
My lord, on the last occasion, your lordships directed this, my lord, Commissioner School Education, my lord,
What is the report?
to calculate the dues and to submit before your lordship. My learned friend, though it was redundant, disputed that whether she has served as school teacher, but I will show your lordships from all the documents. It is mentioned even in the memo of the primary school council, my lord, it is mentioned that she has served as school teacher, but on different pretext, my lord, since 2015, it was directed to, my lord, decide the issue by 31st December 2015 by the division bench. And today we are in 2026, and your lordships given 4 weeks time, my lord, to calculate.
If your lordship kindly takes paragraph 13 of your lordship's order at page 6, my lord, last order.
Yes.
My lord, the middle portion, in order to make calculation, the respondent number 2, Commissioner of School Education, shall be at liberty to call for the records, relevant records from the office of the concerned district inspector of schools, as well as from the school authority. Now, my lord, what has happened is, my lord, we don't have any records because we did not appoint her. My lord, it is my humble submission, if your lordship will kindly direct the commissioner to give them a hearing, let them submit the records, whatever they have, because we don't have any records. The difficulty, what is happening, the practical difficulty in the matter is, my lord, because the appointment was not, my lord, by way of the regular method. The school had appointed her. There is no records. So till the time the pay scale is not fixed, my lord, the retirement benefits cannot be calculated.
So
My lord,
which,
this
is
is
the,
the-
which authority will do that?
My lord, if your under your lordship's order, if your lordship kindly directs the commissioner, your lordship has already directed the commissioner.
Yes.
Now, my lord, she may be directed to produce the records before the commissioner, my lord.
My lord, my learned friend
Because whatever-
has not been properly instructed. My lord, we apprehended this because my learned friend has not gone through the, my lord, documents and also the pleadings of this case, my
My
lord.
lord, may I first
He
my lord,
just,
take my
he just
may I
on the
just hand
other
over
day,
the-
my lord,
Now your lordship will
let
kindly
me
take.
submit.
Sir, I have
you
not
take
finished.
it up.
I have not finished. Then after that, please let me submit. Kindly takes paragraph 9, my lord, of this. At page 2, paragraph 9. The retirement benefits of an employee are admissible on the basis of the last pay drawn by the employee. But in the instant case, the petitioner did not get any salary. Rather, she claimed that she had received consolidated pay remuneration at the rate of rupees 150 and rupees 2000 in April 1988 and November 2015 respectively as teacher cum clerk from the Secretary of School. Now paragraph 13. In the operative part of the note written as the DPSC DI could not submit till date necessary papers and records to ascertain the pay scale drawn by the petitioner in order to calculate the retirement benefit. In this aspect, it is to bring to your kind notice that in this case, Srimati Gauri Santro was appointed by the school council, nor her appointments are approved by the district inspector of school, Kolkata in primary school. The petitioner did not get any pay as salary in specified pay scale as prescribed by the government in rural route. Rather, she claimed that she had received consolidated pay remuneration at the rate of rupees 70 as on 1/11/1979, at the rate of rupees 150 in April 1988, and rupees 2000 in November 2015, respectively as teacher cum clerk from the Secretary of School. The DPSC DI is not in a position to ascertain the pay scale drawn by the petitioner in order to calculate the retirement benefit. The DPPG West Bengal is also opined that hence the petitioner never drawn any pay scale, any scale of pay. Instant case do not come under the purview of this office as per DCRP rule scheme 1981, and you may take urgent action in terms of the recent order in a letter to such. Now, my lord, if your lordship has directed the commissioner, my lord, to ascertain. Now, my lord, the records, she may produce all the records before the commissioner, my lord, so that he can ascertain it, my lord.
Chair, that is approved the appointment is a post facto solely for the.
My lord,
But this
my lord,
analogy,
my lord, kindly permit
What
me
is
on
going
behalf
on,
of the state.
where we are going wrong is that
Yes. Well, this has to be
first
solved
writ
first of all.
petition,
Yes.
first writ petition,
Yes.
there was a direction.
Yes.
See, I have quoted in para 5 of the order.
Yes.
In the event the Commissioner of School Education, after taking evidence to be adduced by the writ petitioner, the concerned school and the state,
Yes.
is of the opinion that balance of probabilities is in favor of an answer aforesaid questions in the affirmative,
Yes.
he shall in that case approve the appointment.
Post facto.
Now again putting the bag to the petitioner that you produce
I
it,
know.
because there was an order which has
Yes,
reached its
yes,
finality.
My lord.
Now you have to ascertain, and if it is found on evidence that the approval is to be given, you give that approval, and then you calculate the retirement
They have
benefit.
given approval.
Again, we are going back to that square one.
My lord.
My lord, because
This
My
is
lord,
difficult because
apprehending.
No,
Now,
my lord, this has to be solved.
Let me say, my
because
friend, this is
this
my
was
application.
at that point of time in the year 2011 when the writ petition was disposed of. As you have submitted, the issue was same before the court. There are framed 4 questions: whether she joined, whether she
Immediate
discharged as function. All these have been resolved by the
My lord.
court, saying that you take evidence. If you find, give approval to grant the benefit of the retirement benefit to the petitioner. Now, again, if they say that this has to be produced, then
My lord, because my lord, what is happening is, my lord, the records. My lord, if they can produce the records, because my lord, my client does not have the records because we did not appoint them, my lord. The school appointed them, my lord. So either if they can produce the records before the commissioner,
My lord, there is
because
no
otherwise,
scope.
what will be the pay scale, my lord? Now
What
that is
I-
the difficulty.
I bow down before your lordship, since your lordships has, my lord, observed that, my lord, the entire thing has already been settled by the division bench, subsequent by coordinate bench, and after going through both the orders, your lordship has passed the order. So there is no scope, my lord, to reopen it. Moreover, my lord, apprehending that the mischief will continue because the government has changed, but the bureaucratic, my lord, system has not been changed. The staffs has not been changed. That is why, as an abandoned precaution, my lord, I could have, my lord, submitted 56 acquaintance roll where I signed as a teacher, my lord, somewhere I have signed as a teacher cum clerk. All those documents were handed over to, this is affidavit of service, to the authority. My lord, he is posing something which they have not known.
Well,
I
don't know
will
what
see,
he has
my lord, the
copied in, sir.
acknowledgement. This is not my job, but I have done it to their satisfaction, that I have served as a teacher. And moreover, if your lordship kindly,
after the order passed by the
lord.
honorable division bench,
My lord.
the commissioner has passed order.
No, my
He
lord.
has given
Commissioner-
his findings with regard to the 4 questions that were framed,
Yes.
and it was found to be affirmative. Now there is
From
no
70.
question of again finding out what was the pay scale. You give approval and find out what would be the pay scale at that point of time.
Well, then the state, my lord, because
My lord, just we are filing our instruction.
we have no problem.
copy the now.
Because if it's wrong, Then-
अपना कोई copy up to date.
its first paragraph, it says that the approval is modified with effect from
Yes,
1979.
that is modified, my lord. But my
Now
lord,
you calculate what are the other things that is to be done, because everything cannot be stated by the court.
Yes,
It is
my
for
lord.
the,
I appreciate, my lord, this is to be done by the commissioner. Kindly, my lord, direct the commissioner, my lord, because otherwise,
It was directed, but he is taking so much
well,
time.
I'm not justifying the commissioner's action, my lord. I'm not appearing for the commissioner. I'm appearing for DPSC, my lord.
acquaintance rule. Who is, you are for the district primary school council. Now the deputy director of school education says that district primary school council cannot produce.
My lord, because, my
He
lord,
says that his client has already produced the acquaintance rule.
My lord,
my lord, your lordship will recall, in the writ petition also, the acquaintance role which they had annexed. His client's name was
my
not
lord,
there.
that is why he pointed
I
out
pointed
that
it out before your
annually.
lordship, and that is why lordship said, my lord, the records may be produced
My
before
lord,
the
kindly,
commissioner.
kindly see, my lord,
So, my
for a
lord, whether
moment,
these
my lord.
records have been produced before the commissioner by my learned friend's client,
But
my
my
lord.
learned friend has gone through the petition, my lord. Kindly come to page 28 for a moment.
Mr. Roy, do one thing. I grant you liberty. Since you have produced, you have a copy of that acquaintance rule. The report of the state also says that they could not produce the acquaintance rule. To resolve the issue, you produce the acquaintance rule.
My
in
lord,
the
I have
office of the-
produced. Okay,
Which-
kindly see the affidavit of service where it was written.
in 26
53 which are available with me, I have produced sufficient document. And
Sir,
kindly,
Mr. Singh,
My lord.
then you take proper instruction. In 14 July 26, after the passing of the order, he has produced that acquaintance rule.
Copy touches.
my lord, kindly come to page 28 for a moment. Page 28, kindly come. This controversy cannot reopen, my lord, because after the division bench order, but still I will satisfy your lordship that my learned friend and the department has not gone through the documents. My lord, page 28. This is the letter of the my lord secretary of the school, my lord. My lord, your lordship got it.
Yes.
Page 20. We beg to state that the Srimati Gauri Shatra is an unapproved teacher of this school. She has been working in this school since November 1979. This first document. Then, my lord, kindly come to page 30, my lord. Page 30. In the middle, my lord. In the second paragraph. My lord, that was written by the head teacher of the school to the district inspector of schools. আমার আরো একটি বিনীত নিবেদন এই যে আমাদের বিদ্যালয়ে 1979 সাল হইতে দুইজন অননুমোদিত শিক্ষিকা আছেন, শ্রীমতী সীমা নিয়োগী ও শ্রীমতী গৌরী সাঁতরা. That is there. Then, my lord, kindly come to page 32. Page 32, my lord, kindly see the 4 teachers who were not approved.
How-
Their names were given. Page 32. And Gauri Shatra is second, my lord.
Shall be at liberty call for records.
Then kindly
Report
come,
filed by the report
then kindly
filed by
come
the
to page
state
34.
is
My
taken
lord, even the primary school council's memo, I will show your lordship.
by order dated. You are also filing this instruction. Instruction
Copy the report. Hey, reporter copy the. Reporter copy the.
ওটা কোনো report নেই, internal
filed
communication.
by
Internal communication.
the district inspector of
Report ওরা file করছে।
this is district inspector of schools. This is filing
My
by.
lord.
You have filed this.
Right.
Where is your report? It is not coming from the side of the state.
We have just already filed.
No, this you have handed over, Mr. Kankani.
My
This-
lord, this is the instruction, my lord, which we had received from, my lord, there's a communication between the
There
office
will be no record, Miller, only on his
the
oral
district
submission
inspector
to
to
the
the
bar.
commissioner, my lord.
This you are placing on record because state is not coming up with this report.
My lord, state is, my lord, this is, I'm disclosing it before your lordship, my lord, so that,
Communication, letter of communication made by District Inspector of Schools, PE, Kolkata, dated 27 July 2026, submitted by the Kolkata DPSC is also taken on record. By order dated 30th June 2026, following direction was issued. Para 13 set out. The report submitted by the state furnished by Deputy Director of School Education, West Bengal, records that the approval of service of the petitioner is modified with effect from 1st November 1979. However, The calculation as directed by this court regarding the retirement benefits of the petitioner could not be made since the Kolkata DPSC failed to produce acquaintance roll. Para. Mr. Pradeep Kumar Roy, learned senior advocate appearing for the petitioners, submits that on 14 July 2026, the petitioner has already submitted the acquaintance roll contained in 55 pages. In view of the above, the Commissioner of School Education, response number 2 is directed to calculate the retirement benefits taking into consideration the acquaintance roll. Upon verification of the acquaintance roll submitted by the petitioner before it on 14 July 2026, it is directed to furnish a compliance report on the returnable date.
One indulgence, may I
Yes.
take, my lord? One indulgence. Page 43 for a moment, kindly see. This issue was resolved, my lord. Page 10, paragraph 10. Page 43, paragraph 10. The chairman, Kolkata Primary School Council, by letter dated so and so addressed to the Commissioner of School Education, West Bengal, submitted that since the department had not approved the service of the unapproved assistant teacher, Srimati Gauri Chhatra, he is now not in a position. My lord, they have also know that she was working as an assistant teacher. So, my lord, they have created the controversy on the other day only to, my lord,
Resolve the issue. Mr. Singh, the Commissioner has been directed to take into consideration and verify the documents of acquaintance roll that is filed by the petitioner in 14 July 2026. You verify that and comply the order and file a compliance report on the returnable date. কতদিন time ছিল?
4 weeks there, last time 4 weeks was given.
Okay, do it by the end of আজকে কত তারিখ? 25th. 4 weeks পরেই রাখুন অগস্টের এন্ডে। অগস্টের এন্ডে একটা ডেট বলুন। 25th August ওপরের দিকে রাখবেন।
My lord, that should be preemptory, my lord, because I am suffering since 1981.
But until and unless they calculate, because the court's hands to also not be tied by issuing a peremptory order, because there has to be some orders to be passed upon the Commissioner of School Education.
My lord,
if they don't comply.
that was there, they didn't comply.
Please see that it is complied with, because he is suffering. Mr. Roy is last time also since 2011. It's high time that you come to a conclusion. Okay, on 25th.
The commissioner has to take a decision. My lord, the difficulty is.
Now he has submitted the documents. Now you
Yes,
take a
now he
decision.
has submitted, my lord, commissioner. Great.
Yes.
I am the petitioner.
My lord, I am submitting the
My
report
lord,
on
the
behalf of.
petitioner apply for the family pension as a disabled person, my lord. The DPPG authority, my lord, asking the death certificate of mother, my lord. Kindly recall this, my lord. In this regard, your lordship directed.
Oh, yes, yes. What
My
is
lord, I am submitting the report, your lord. The copy has been submitted. My lord, this is the inquiry report of the BDO, your lordship.
page of the government being authorized?
Yes, my lord.
This is also silent with regard to death of the mother.
My lord, it is clear, my lord, all the legal years, absence of the wife of the deceased teacher, my lord.
Prior to retirement, she died.
My lord,
Prior to retirement.
long ago.
When did she die?
1980.
80.
My lord. It 99.
Where is that affidavit before the first class judicial magistrate?
All the documents are submitted before the DI, my lord. My lord, the list of the this phase 21, my lord, can you see, my lord, all the documents which you have submitted before the DI, my lord. List provide, my lord. Phase 21.
No, the affidavit that was submitted, where is that?
My lord, I have not any no objection certificate. Affidavit, my lord, legal year certificate. I have not any, my lord, but the only, my lord, death certificate is DPPG, can't see, my lord, page 33, my lord. Only asking for the death certificate of the deceased employee's wife, the deceased's mother, my lord. 33. Asking for the death certificate.
Panchayat certificate?
Yes, my lord.
Where is that?
My lord, page 32, my lord. My lord.
Asha. report filed by the state respondents furnished by Additional District Magistrate General Birbhum, dated 23rd July 2026, is taken on record. Added response number 6 for the petitioner contains that he is by the present writ petition, the petitioner seeks direction upon Annexure P5, page number. এটা reconciliation.
Page 23.
P7,
This one representation, 26.
no, P7 is yes. Why you have fought for recalling of Annexure P5? It will be Annexure P6. P5 to a P6 it.
Communication letter, P6 communication letter, the DI, TPPG.
Recall or upon the respondent, particularly respondent number 2, directed DPPG to recall and quash the audit observation under memo dated 28th January 2025, Annexure P5, and memo dated 14 July 2025, Annexure P7. The petitioner contains that he is a disabled son of the deceased employee. The petitioner applied for getting family pension. The family pension has not yet been granted in favor of the petitioner on the ground that the petitioner could not produce the proper death certificate of his mother, namely Salehar Khatun, who died in the year 1980. Challenging such action, the petitioner has filed the present writ petition. None. The petitioner's father was an assistant teacher at the Prothame Devan. Akash Hussain, late Akash Hussain, was an assistant teacher in which school?
Sadinagar Primary School.
Teacher in Kalipur Primary School under Nanu South Circle, District Birbhum, who retired from service on superannuation on 31st January 1999. The petitioner's father expired on, he died on
20 April 2023.
20th April 2023. Upon such demise of his father, the petitioner made an application seeking for grant of family pension. Mr. So-and-so learned, hence challenging such action, this writ petition has been filed. Mr. So-and-so learned advocate for the petitioner submits that only on the ground that the petitioner failed to produce the death certificate of his mother, the family pension has not been granted in favor of the petitioner, who is a disabled son of the deceased employee. The petitioner has produced the legal year certificate issued by Additional District Magistrate General Birbhum, which has not been taken into consideration. This was submitted before the authority,
My lord.
which has not been taken into consideration by the authority concerned at the time of deciding the application of the petitioner for grant of family pension. He seeks for setting aside of the impugned memo of Assistant Director, Pension Provident Fund and Group Insurance Finance Department dated 28 January 2025. And the other letter is that?
Subsequently, page 33, 14 July 25. Page 23, 33. Before last time.
33. July 2025. And also 14 July 2025. The report para state, the advocate for the state submits that since the petitioner failed to produce the death certificate of his mother, for the course of action with regard to grant of family pension of the petitioner could not be proceeded with. Para. The report filed by added respond number 6, Additional District Magistrate General Birbhum, shows that the legal year certificate was issued on 27th May 2024 on the basis of an inquiry report of BDO Nanur Development Block. Such inquiry report of BDO Nanur Development Block has also been enclosed. It is found from the aforesaid inquiry report that the block development officer, prior to submission of the inquiry, during inquiry, visited the residence of late Akash Hossain at village Sadinagar Post, Patnil Pin 731302 PS Kirnahar of Dakshal Gram Karya 2 GP under Nanur Development Block, and also made a local inquiry. And thereafter, he forwarded such inquiry report to the District Magistrate, RM Section Birbhum on 23rd April 2024, stating the names of the legal heirs of the deceased employee. The list of the legal years of the deceased employee does not include the name of the mother of the petitioner. The legal year certificate so issued has been stated to have been issued for getting only pensionary/death benefit to the years of the deceased ex-government employee. It is categorical contention of the petitioner that such document has not been taken into consideration. In the aforesaid conspectus, the memo dated such and such 28th January 2025 and 14th July 2025 of Assistant Director, Pension Provident Fund and Group Insurance Finance Department. Respond number is 2 is set aside. Director, set aside. The District Inspector of Schools is accordingly the District Inspector of Schools, Primary Education, Birbhum is directed to take steps for grant of family pension to the petitioner, taking into consideration the legal year certificate issued by respond number 6, Additional District Magistrate General, Birbhum, dated 27th May 2024, which is annexure P5 of the writ petition. Within a period of 6 weeks from date of communication of this order, and further take all consequential steps. Disposed of. On the basis of the legal year certificate that you have submitted, he will take a decision on that. Upon notice to the petition.
Nine, I am for the petition.
What is this?
The direction to take instruction will be
take necessary matter of written. What instruction?
the I tell you, will be in 2009, 2007, the recruitment process was started for primary teacher by the Hooghly District Primary School Council. The 1st December 2009, 20th December 2009, page 23, interview was, written test was, examination was, written test was held, and petitioners being the untrained candidate participated at the said selection process. The panel was prepared in the month of January 2010, but the number of candidates who obtained the training qualification from the unrecognized NCT institution, unrecognized institution not recognized by the NCT. They obtained training qualifications and awarding 22 marks, and they have been included in the panel. The batch of the candidates, untrained candidates, challenged the selection process. The Honorable Single Judge dismissed the writ petitions that they know. Petitioners, being untrained candidate, have no right to challenge that, since they are given mark, they are awarded marks, not above the cut-off marks. This is the ultimately, the appeal was paper. The Honorable Division says that since this Honorable Court declared that in Tulsi Boxi's case, that the training qualification obtained from the institutions not recognized by the NCT, so they are not eligible for 22 marks and not included in the panel. The honorable division bench, your lordship will find just the facts of the case. Honorable division bench, your lordship, just the page 54, page 98. Honorable division bench, operative part, page 98. Operative part, the last paragraph. The aforesaid appeal are disposed of by directing the authority to, petitioners is also in the one of the candidate in the appeal. The aforesaid appeals are disposed of directing the authority to prepare a panel on merit wise, which would include all candidates of the unreserved and reserved category, and in the event any of the applicants are found having obtained more than marks than the last cut of marks as disclosed in the writ petitions, they shall be given an appointment in the existing vacancy or anticipated vacancy for this year or future year. This is the judgment of the Honorable Division Bench delivered on the appeal also, the petitioner's appeal also was 2nd December 2024. And the single bench judgment was delivered on
9th August 2019.
9th August 2019. The state has preferred an special petition before the Honorable Supreme Court, page 100. The SLP was also dismissed. Thereafter, contempt application was filed. Ultimately, appointment was given to me, page 109. 1st August 2025. This is my appointment letter.
Okay.
The pursuant to the appointment letter, I join next page, 13th August 2025. By this time, from 2010 to 2025 entire period, that is the entirely the wrongful action of the state authority. Now I retired from service 20th February 2026. I rendered service only 8 months, 6 months, 90 days.
Only 6 months?
Only 6 months.
Then
the petitioner's prayer before your lordships, direct the authority to consider the national benefits, so that only for the purpose of pensionary benefits. The entire, I have also the judgment of this honorable court that the action of the state authorities, the impanel candidate cannot be penalized. Reported. This is the only prayer, the petitioners claim, only for the purpose of pensionary benefit, national benefits. Panel was prepared on January 2010. From that, the petition was filed. Ultimately, judgment was delivered. Petition bench, Supreme Court. This is the only issue for your lordship.
yes.
So for the before that, kindly consider this judgment also, paragraph 11.
The copy that.
Reported judgment are key copy.
Down.
Paragraph 11 and 12. Reported judgment.
2000 copy 11 na?
Copy down.
SCC online করা আছে
না তুই সিএচটা বল
সাইটেশনটা বলো
কত 2000
2023 5
দিয়েছেন পাতা শুরু আমি তো বিশ্ববিদ্যালয় তুমি এতক্ষণ ধরে গল্প করছি মন্ডল
মোহনটা জাজমেন্টটা ভাই এটা কেমন judgment হাওড়ার কেস আছে বেশি কি করবে
হ্যাঁ আমি তো তাই বলছি কি
বেশি পয়সা দেওয়ার অথরিটি প্যারাগ্রাফ 10 মানে দি রিলাইং দ্য ডিভিশন অনারেবল ডিভিশন বেঞ্চ জাজমেন্ট পেনশন দিতে হবে দেখিয়ে মতো দেখিয়েছে
What was the fact of this case?
I had the occasion to appear because
Okay.
I know this fact. But in respect of Sumon also same thing happened in paragraph 10. In respect of Howrah.
You come to paragraph 11.
Yes.
This was a case. This was a case.
This was the case because that
See?
section also Sumon
Paragraph number 11. Then I put the query.
considering the 10 paragraph 11.
Paragraph page line number 4.
Line number 4. Paragraph 11. It says,
line number 4
Shumohan this court is of the considered view that the date on which the decision is taken to the forward the name of the petitioner before the director of secretary shall be treated to be the date of appointment notionally for the purpose of notional benefit. But since the selection process started in the year 2009, it is to be attributable delay to the conducting authorities. And for the present petitioner, therefore direction for consideration. Taking Q of this. This is in respect of Howrah Sumohan, in respect of my petition in other.
no not
But here,
date
Sense.
2014 my lord also my lord the past year this is that different thing but my lord also
proceedings.
Date was not there. তখন টেট ছিল না
না এটা তো কোর্ট প্রসিডিং এর জন্য ডিলে হয়েছে
হ্যাঁ কোর্স প্রসিডিংটা ডিলে যেটা হয়েছে সেটা নট অ্যাট্রিবিউটেবল টু দ্য পিটিশনার দেয়ারফর ইন্টারভিউ
my lord
Yes.
so far the judgment that has been referred to and with the case is concerned my lord if lordship go by this case my lord then lordship will find my lord that initially there is a direction 11% was appointed challenging that my lord this petitioner has filed this case that was dismissed the appeal preferred but in the appeal my lord lordship will find my lord kindly comes to the concluding portion of page 98 page 98 my lord prior to that kindly comes to page 97 once page 97 97 my lord there appears the word starts with I'm sorry there appears to be a fallacy in the submission of the respondent in this regard. The challenge is not made in the entire panel prepared by the selection committee, but is restricted to 11 candidates who have been
placed in the separate panel as a trained candidates. The aforesaid 11 candidates are arranged as a party in the writ petition as well as in the instant mandamus appeal as per number 5 to 15. The notices were given to them, yet they chose not to appear in the proceedings, and therefore it cannot be said that they are not made a party to the proceedings. There is no fetter on the part of the court to proceed and decide the matter ex parte against those 11 candidates who, despite the service, chose not to defend the or contest the same. The contention of the respondent that all the candidates who have shown in the panels and given an appointment are to be made party in is unfounded in view of the limited scope of adjudication. What would be the remedy or the reliefs which can be given to the appellants in the instant case? We are not unminded of the situation that a candidate who have been serving for more than a decade should not be thrown out because of such irregularities having committed by the authorities. But equally, we cannot overlook the enforceable right of the appellants who were deprived of such right in the hands of the executive. We are conscious that the Ananya Banerjee, the appointment of 11 candidates were challenged and the court held that such appointment is not illegal. Simultaneously, the court directed the authorities to prepare the panel strictly in terms of Rule 9(8) of the said rules, which appears to have been misconstrued by the authorities that no further action is required to be taken. The direction passed in the Ananya Banerjee Supra is explicit and clear that the authorities were directed to prepare the panel on the merit-wise irrespective of the reserved categories and thereafter to proceed in accordance with the aforesaid provisions. We set aside the order of the trial court by which the writ petition was dismissed on the score that the moment the appointments of the aforesaid 11 candidates were found to be legal, no interference in this regard is warranted. The aforesaid appeal are disposed of by directing the authorities to prepare a panel on merit-wise, which would include all the candidates of the unreserved and reserved category. In the event any of the applicants are found having obtained more marks than the cut-off marks as disclosed in the writ petition, they shall be given an appointment in the existing vacancy or anticipated vacancy for this year or future year. Now, my lord, application is thus disposed of. Now, my lord, if lordship gone through what I have read, my lord, first and foremost things is, my lord, the court has directed to prepare a panel. Accordingly, my lord, the panel was prepared. The District Primary School Council Hooghly prepared, my lord, 79 candidate panel. Out of 79, my lord, 62% get appointment. 63, I'm sorry, my lord. Rest persons are not getting appointment because of the reason, my lord, they have not come within the purview of that cut-off marks. The cut-off marks has been fixed by this petitioner in their writ petition, 42 or something like that, my lord. Now, this petitioner, my lord, has filed the contempt application. After this SLP has been preferred, dismissed, thereafter they preferred contempt. During pendency of the contempt, my lord, 62% got appointment. In this order, my lord, will not find a single word with regard to the date of from which date they will give the appointment. The date of appointment mentioned as and when this panel was prepared, thereafter they will give the appointment. In the appointments, my lord, when they receive the appointment in 2025, my lord, there is no whisper with regard to the fact that all these pending proceedings and all. And in the order itself, my lord, there is no whisper with regard to whether this would be a prospective or retrospective. That should be made because my lord, court says, my lord, I am not unminded fool that they have been working and all. But at least, my lord, if division bench, my lord, does ultimately division bench, what division bench held, my lord, that prepare a panel and those persons who are entitled to get, they are my lord, within the zone of consideration, they will give the appointment. Accordingly, my lord, appointment was given to them. Most of the persons, my lord, working for 6 months, someone has 4 months, someone has 3 months, someone has 1 month, like that, my lord, and they retire. Now, my lord, the question is, my lord, when there is no, where the court is absolutely silent with regard to that part, that from which date So here, my lord, it has been a slight mentioning as being there from the date of appointment. So here, my lord, they have getting the appointment in 2025. How did they claim the notional benefit? Maybe, my lord, notional benefit is not a monetary benefit, but after that, my lord, they will claim the pension and all these things. How did, my lord, when a person does not work, his appointment is in 2025. He has accepted that without any demur. My lord, now the question of notional benefit, how it arises? If I ask this question to myself, when the court has said, but I am not unmindedful with regard to the fact that they are working for a decade and all, but still, my lord, the court directs the authority, my lord, to prepare a panel, send it to the authority concerned. Thereafter, who has come within the zone of consideration, they will get the appointment. Accordingly, my lord, 62 plus 1, 63% has get appointment. 13 or 14% has opted out because they have not come within the zone of consideration. So where is the question of national benefit come after this division bench, which has been affirmed by the Supreme Court?
Okay. Yes.
Yes, my lord. They have been, the petitioner was appointed on 13th August 2025.
Okay. Any other submissions?
But he has accepted the appointment.
Hmm.
And my lord, the delay was not due to the respondent. It is due to the legal proceeding.
But that has also been discussed in the
No.
division bench, my lord.
The-
Division bench holds, my lord. I am not unmindedful with
Just
regard
a
to the
minute.
fact.
Page 98, Honorable Division Bench held that if in the event any applicants are found having obtained more than marks than the last cut-off marks.
Yes.
So it is admittedly, my lord, I got, my lord, the more marks, my lord, more than the last cut-off marks. That is why, my lord, I have been included in the panel in pursuance of the division bench order.
I have
And
said that.
ultimately I got appointment
I
letter.
have not denied that. I have said
This
that.
is the delay caused by the state.
No,
No, my lord.
Then because
There
of
is-
the wrongful action of the state,
there is no whisper, my lord, in the division bench.
admittedly, it is found that I got more marks than the last cut-off marks. This is the order of the honorable division bench. That is why, my lord,
11 candidates were given appointment from which date?
From in 2009, they have got the appointment in terms of the
Yes,
order
they
of
are-
this
they are
court.
different aspect. That is their
No, they
their
have challenged that
appointment.
11%
Very-
will not entitled to get. But
Their
ultimately,
appointments have not
in
been
Ananda
discharged.
Banerjee's case, my lord, it has found, my lord, no, they are genuine candidates. They are trained candidates. Challenging that, they have filed this single bench dismiss division bench. Lordship has seen the division bench observation. Division bench has held, my lord, if they have come within the zone of consideration, give the appointment. So according the appointment was given, there is no whisper with regard to the fact that from which date they will give the appointment. When the court holds, my lord, that we are not unmindedful with regard to the facts that they are working so and so, so and so, so and so. But at least, my lord, if the court holds, my lord, that yes, they should give a retrospective effect from the date of 2009 and all. Nothing has been decided. Nothing has been said that in the order, my lord. In earlier orders, my lord, it has been mentioned, my lord, that they should give the retrospective appointment from 2001 or
never
2002.
directed to issue appointment letter.
Court has said, my lord,
Observe whether I am entitled, eligible or
the
not.
entitled, my lord, if out of 79, my lord, 63 got the appointment.
69, 63, I would in the.
He has
I
come
have
within
letter-
this, within 63. So I am not disputing with regard to the appointment. The only question is, my lord, he has accepted this without any demur. In 2025, my lord, if he said, my lord, I am entitled to get because of this, that you have given me the appointment. I have received this appointment without prejudice to my rights and nothing of that sort, my lord. Now he has filed a case claiming that I am entitled to get the notional benefit from 2009 when I am working only for 6 months. This is my submission, my lord.
Okay. Ashwin?
কটা অ্যাপ্লিকেশন আছে তোমার নাকি অনেক অ্যাপ্লিকেশন ফাইল করেছো ডিপিএসসি বলবে আমি বলেছি সব নামগুলো পাঠান কিছু
By the present writ petition, the petitioner seeks direction upon the respondent authorities, particularly response 3 and 4 to consider the prayer of the petitioner for notional benefits from the date of publication of panel prepared in pursuance of selection made in the year 2000, that is 1st January 2010, and take all consequential steps in favor of the petitioner, reckoning her service from 1st January 2010 to 28 February 2026. The petitioner contends that he participated in the selection process for recruitment of assistant teacher in primary school within the district of Hooghly, conducted by Hooghly District Primary School Council in pursuance to notification dated 3rd December 2009. The name of the petitioner was sponsored by the Employment Exchange.
ইনস্ট্রাকশন ফুল ইনস্ট্রাকশন ডিআই টাকা দিলে টাকা চেয়ারম্যান ডিসাইড করবে পাগল
On the basis of the petitioner appeared in the written test examination held on 20th December 2009. However, the petitioner's name was not included in the panel of successful candidates. The petitioner, along with others similarly situated candidates, challenged the selection process, challenging the same on the ground that additional marks towards training qualification has been granted to the candidates who did not undertake teachers training course from NCTE recognized institutions. On such score, the petitioner made a representation before the authority concerned, which was rejected. To have redressal of her grievance, the petitioner filed a writ petition being WP 26394 W of 2014, which was taken up along with other writ petitions and was dismissed by the learned single judge, vide judgment dated 9th March 2019. The order of the learned single judge was challenged in appeal, and direction was issued to prepare a panel on merit wise, which would include all the candidates of unreserved and reserved categories, and in the event any of the applicants are found having obtained more marks than the last cut-off marks as disclosed in the writ petitions, they shall be given appointment in existing vacancy or anticipated vacancy for that year or a future year. Special petition was filed before the Honorable Supreme Court, being SLP Civil Diary number 19493 of 2025, which was dismissed on 5th May 2025. Your appointment letter?
Appointment page 109.
The petitioner was given appointment on 1st August 2025 and she joined on 13th August 2025. The petitioner has retired from service on superannuation on which date you have retired?
28th February 2026.
20th February 2026. The petitioner claims notional benefit. The petitioner claims that the length of service of the petitioner should be considered notionally from the date of which date? From which date you are claiming? From
Panel was from the date of publishing the panel.
From the date of publication of the panel,
2010, January 2010.
January 2000.
1st January 2010. Hence this writ petition. Mr. Shaktipat Jana, learned advocate for the petitioner, submits that due to the irregularities in the recruitment process, the petitioner was not given appointment in the year 2010. After several litigations and by dint of order of this court, the petitioner was ultimately given appointment in the year 2025, which ought to have been given in the year 2010 itself. The delay in appointment of the petitioner is not attributable to the petitioner, rather the same is attributable to the conduct of the authorities. Had the appointment of the petitioner could have been given in the year 2010, the petitioner would have completed 10 years of service to be entitled to the pensionary benefits. Due to such conduct of the petitioners, the petitioner is deprived of the pensionary benefits. He seeks that the length of service of the petitioner should be considered notionally from the date of publication of the panel that is 1st January 2010. To buttress his contention, he relies on the decision of a coordinate bench of this court passed in Golbadon Mondol versus State of West Bengal and others, reported in 2023 SCC Online Calcutta 2267. On the contrary, Mr. Bishobroto Basu Mollik, learned advocate representing DPSC Hooghly, submits that the petitioner the order of the learned single judge, in which page it is?
Of the single judge, age 40, start from 40, 40. PSC rejected in 2013. July 2013, DPSC rejected my claim. Paragraph 3 and 6.
Findings of the learned single judge regarding the dismissal. Which paragraph?
Number it starts with
No, that is the
page 51. my lord. Yes.
no. Is
I'm unable.
38.
No, no, 38.
That is not the
No, conclusion. 38 টা তো শুরু. Joseph Judge in conclusion, please, that is starts with
37 and
I am
38.
unable to accept the contention. Page 50, my lord. Kindly comes to page 50, paragraph 34.
No, Mr. Basu Mollik,
My lord.
this finding in para 35 at
Ma'am.
page 50,
Ma'am.
which is the contention that the trained candidates who secured their training from a private institute
That is
which was
Tulsi
not
Boxing Judge.
recognized by NCTE,
Lordship.
this has not been accepted by the learned single judge, and it says that no, it's regular and they should be awarded. This 35 findings in 35 and the division bench's finding with regard to 35, where I will get that.
Lordship.
In which paragraph I will get of the division bench's order?
Paragraph 35.
Paragraph 35 findings of the single judge.
Lordship.
What has been dealt with by the honorable division bench with regard to para 35?
Yes, ma'am. 98.
98.
Thank you.
No, what must be?
Second paragraph. 96 second paragraph. Page 96.
96.
Actually, my lord, the training they have obtained prior to my lord coming of this
Page-
NCT
page
Act.
96
That has
second
been
paragraph, that has
mentioned
been
by. That is why, my lord, the single bench had held, my lord, that no, the training is not required because they have passed their training before coming into the NCT Act. That has been referred in the page 35, my lord. That's what the court my lord, holds that, my lord.
Page 96 second
Now in
paragraph.
division bench's order, where is that
Page
discussion?
96 second paragraph.
No, not this.
No, এটা নয়.
Come to page 30, paragraph 35 of single judge's order. It has dealt with a decision that was referred Tulsi Boxi Supra.
Yes.
Whether the private respondents are to be treated as trained or untrained. And it says that accordingly, I find no illegality in the respondent authority treating private respondent as trained candidates and allotting 22 marks.
No, just a minute. Let me just check it out.
Yes, that has been dealt with by the honorable decision bench. Page paragraph page 96 second paragraph.
না জজ যেটা চাইছেন তুমি সেটা বুঝতে পারছো। জজ সাহেব বলছেন যে তুলসী বক্সি রেফার করে ডিভিশন বেঞ্চের কি আছে বক্তব্য। না এই যে মানে অ্যাফোর্সেড চ্যালেঞ্জ
This is the only aspect which whether there was irregularity, single judge says that no, there is no irregularity of awarding 22 marks. Now this Tulsi Boxi has been referred to. In the division bench's order, show me what is the analogy that has been drawn by the division bench, stating that that finding is incorrect or bad in law, whatever.
Here, Milord, only Milord, the Ananya Banerjee has been referred to because that Ananya Banerjee has.
Tulsi Boxi has been referred page 70, first paragraph. 70.
Yes, but that is the only challenge, my lord. But there is a discussion with regard to the fact what Lordship has, my lord, wants,
Now,
my lord.
ultimately,
Yes,
paragraph
That is not.
95, no, paragraph
দেখে এসো না,
90,
আজকে হবে না মনে হচ্ছে।
96 second paragraph. That is the awarding 22 marks to those candidates cannot be
Easy of
reopened.
it.
That has been dealt with by
Wait.
now. Paragraph 96.
Now, my lord, in page 74, my lord, if Lordship takes, my lord, page 74 once, my lord, in the single bench, what I have argued, my lord. আমি কিছু বলিনি বাবা। সবই তো সুবিধা। পিটিশন অ্যাপেলেন্ট কমলের ক্লায়েন্ট কমল থেকে ছেড়ে দিয়ে তোমার কাছে এসেছে। Page 75.
Yes, 75 করে। হ্যাঁ। Submission.
My lordship, I got it. Page 89, Lord kindly comes.
89.
Yes. We do not find any dissent in applying the standards as provided in the aforementioned provisions. Initially, the appellants took the stand that awarding of 22 marks for training is in contradiction with the division bench judgment of this court rendered in the Tulsi Bokshi Supra, but the appellants have abandoned the said claim and took a stand that even after awarding 22 marks to the respondent number 5 to 15, total marks so obtained by them is less than the marks obtained by the respective appellants, and therefore they should be included in the panel. The entire argument resolves around the interpretation of sub-rule 6 of rule 6 of the said rules as quoted above, and the meaning to be given to the word priority or preference in juxtaposition with the stand of the state to segregate the class in preparing a separate panel for the trained category candidates.
এটা কি আবার করেছে তোমার?
না, রেকর্ড তুলসী বক্সি তোমার ক্লায়েন্ট চেঞ্জ করে দিল স্ট্যান্ড।
কি বললাম বলুন তো? Submits that upon dismissal of the order of the learned single judge, setting aside, the Honorable Division Bench directed for preparation of the panel, and whosoever was entitled to appointment, the same has been granted. There is no such direction in the appeals court's order that the same should be considered. The appointment should be considered notionally from January 2010. Admittedly, the petitioner did not challenge the petitioner and other candidates did not challenge the entire panel. The challenge was restricted to 11 candidates. The petitioner joined the service with the knowledge that she will be discharging her functions for 6 months only. The joining of the petitioner is without any demur. Therefore, the petitioner cannot claim notionally from January 2010. Similar submission is advanced on behalf of the state. আচ্ছা ওপরে এটা করো মিস্টার বাসু মল্লিকের একটু কন্টিনিউ করো। The decision in Golbadhan Mondol is distinguishable in facts with the present situation. The delay cannot be attributed to the authorities. He seeks for dismissal of the writ petition. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the petitioner is entitled to have the length of service notionally considered from 1st January 2010. Para. The petitioner who participated in the recruitment process of 2009 was not impaneled. The petitioner, along with others, challenged the awarding of additional 22 marks to 11 candidates on the basis of their training, which has been obtained from institutes not recognized by the NCTE, and filed writ petition being WPA. What is your number? That number is 26
26394.
26394 W of 2014. The writ petition was dismissed by the coordinate bench of this court, holding that there is no irregularity or illegality in the respondent authorities treating the private respondents within bracket, that is 11 candidates, as trained candidates and allotting 22 marks to them as contemplated in Rule 9 of 2001 rules. আগে কি বললাম dismissed করলো? He said order was challenged in appeal. Being appeal নাম্বারটা কত? ম্যাট না FMA? Your FMA number is
Appeal.
252 of 2021 along with other appeal, which was disposed of with the following order. At 11. Page 98.
It's 57. 57.
In compliance to the aforesaid the panel was prepared and the petitioner was granted appointment on such and such date, 1st August 2025. Supreme Court dismiss করছে, SLP was dismissed. Considering the nature of challenge, it is found that the earlier panel of trained candidates, 11 trained candidates, was challenged on the ground of whether they should be considered as a trained candidates or not. From the appeals court order, it appears that there is no such there is direction to prepare the panel without there being any specific direction of considering such appointment notionally. The challenge was against 11 candidates and not of the entire panel. The decision in Goal Badan Mondol Supra is factually distinguishable. It is not in dispute, but undeniably the petitioner joined the service knowing fully well that she is to retire after 6 months. And that too, no objection was raised at the time of joining. Considering the aforesaid facts, this writ petition falls out of merit, accordingly dismissed. Next.
Item 10. I am for the petition.
Now for the DPSC Hooghly lordship.
This point is not racing in respect of the A category scale of pay. Our petitioner joined the post in the year 2000, 28th July 2000. Now he completed the course in the year 2006. And awarded it from the year 2011, as you also held in other matters. I have brought that. Now, in the meantime, the authority has page 52. Kindly see in terms of the division bench judgment, thereafter another single bench judgment. Your lordship quoting all these judgment, division bench and single bench, pass the order entitlement. Kindly take page 52. 52.
কবেকার ডেটটা রে বাবা?
Date 26/12/2025. Just prior to my retirement held. In reference to the above, the undersigned is to inform him that the above mentioned teacher under his or her circle may not be entitled it will be to get the training benefit with effect from 14/7/2011 as per available existing rule because of the teacher passed in the year PTTI course to 5 to the 5. Whether this is not overreaching, I am asking to myself. Even then, the division bench held that I am entitled with the effect from 2006. My minor judgment is there. Kindly take it. I am praying for quashing of this impugned order. Kindly take your lordship in judgment of my Lord Justice Somensen, as well as I have annexed those judgment itself, and Justice Mantha, paragraph 10 onwards.
Page number?
Page কত?
Page number?
Page number 4.
জাজমেন্টের পাতা কত? লিস্টে রিট পিটিশনে কত নম্বর?
Justice Mantha's judgment is in repetition annex. Your lordship judgment I have just handed over. Can you take page 4? এটা আলাদা একটা কপি আছে?
Oh, yes.
My lord got it.
Past in Khelaram Dhara versus.
Paragraph 11. In the line of those judgments, your lordship quoted, accordingly, in the line of the aforesaid decisions, the petitioner is entitled to a category scale with effect from June 2006. I have completed paragraph 4 and 8. I have stated this. And similarly, it was granted in the year 2011.
Yes, Mr.
So already it has been settled that that has not been traveled to
only
appeal
one
court, my lord.
prayer after my lord paragraph 11 refixation is to be made because I am entitled from 2006 year to year increment. If that is the refixation is to be done. An area
2 months. No.
এটা বলা নেই, ওটা refixation হবে যদি এই ক্যাটাগরি পাই ওই থেকে 6 থেকে
একটা মামলা
Pass all.
Yes, lordship has
Pass all
already decided
consequential
issue.
orders.
That's right.
my lord. Only one paragraph will be added for refixation and area. And that is not the
No, that is not the prayer.
এই পেয়ার আছে দেখো পেয়ার ডি
Prayer দি অনেক দূরে।
Affidavit of service filed on
No,
behalf of
this
the
is it.
petitioner is
I
taken on
understand, get
record
it.
by the present writ petition. The petitioner seeks direction upon
DI
the respondent authorities, particularly district inspector, respond number 3, district inspector of schools,
is the P হবে
PE, Hooghly, respond number 5,
I believe so
5, to extend a category scale of pay to the petitioner from the date of completion of
yes 5
teachers training. Where is that teachers training course?
it is there and I have stated in paragraph 16 I have stated in the year 2005-6 session I have completed
For the session 2005-2006,
my lord paragraph 16
the examination of which was held in February 2011.
it was completed And my result was published in the year 2011. Your lordship, in your lordship's judgment also it is there.
Okay. The petitioner contains that,
Paragraph 4, it has been submitted.
no, the certificate at page 29.
Yes, publication, after publication certificate issued in 11.
So, examination completed in February 2011.
My lord. Course completed 5/6.
Petitioner contains that he joined as an assistant
Order is here.
teacher. In which school you joined?
Well, in the school, I have stated also, my lord, if your lordship kindly take page 30. Second column. Teleni Para, Bhadreshwar Primary School.
Page
Page 30.
30 serial number.
Serial number 2, petitioner, Tarak Chandra Dhul,
Telini Pada Bhadreshwar Primary School.
Chandannagar Circle, with effect from 27/2000.
In the year
2020.
This is date of appointment, joined on
20th July 2000.
joining date.
Joining the date of appointment is the third column.
Joined on 20th July 2000.
আমাকে দিয়েছে এই থেকে, আমি পাবো 6 থেকে।
Under ওটা স্কুলের পরে না, under district primary school council হুগলি।
এটা দেখলে তুমি পুরোটাই বেরিয়ে যাবে ছকটা।
As an untrained candidate, subsequent thereto, he was never transferred. He was
No.
Acha. The petitioner completed primary teachers training course for the session 2005-2006, the results of which were declared on 4th July 2019. This is what has been recorded in this order. 4th July is the date of declaration.
4th July, in my case, my lord, 14 July 2011. Your lordship kindly take page 30 itself, column number 4, training benefit with effect from, because on that date it was there.
14th July
14 July 2011.
11.
I am getting.
Okay.
It will be from the 2006. Pair B I have stated.
এখানে রেজাল্ট ডিক্লেয়ার করবে কোনটা?
In paragraph 16, my lord, Mr. Biswas has stated everything.
Yes.
Paragraph
16.
16. Take paragraph 16
at
page 12.
Page 12.
The petitioner's 2000, he was appointed in their 2000 assistant teacher under DPSC UD. In the session 2005-6, he was admitted PTTI. The result published in 2011.
11.
Thereafter, my lord, after that,
Thereafter,
he
he
has
was-
been promoted as head teacher in 2013.
Yeah. The petitioner was appointed as head teacher of Netaji Vidyapit on 17th December 2013.
Head teacher. Hmm.
ওপরের ওই যে published on হয়েছে 14 July 2011. Date of result. The petitioner retired from service on superannuation on 31st January 2026. On the verge of retirement, the petitioner was served with a memorandum
At page 52.
dated 26 December 2025
It is at page 52.
of by the which authority?
Yes, by the sub
Hugli, DPSC Hugli.
DBS. Yes.
DPSC Hugli, stating that he is not entitled to get training benefit on and from 14 July 2011 as per available existing rule because the teacher passed 1-year PTTI course after 1st January 2006.
Okay. Mat number to bol.
The petitioner claims A category scale of pay ought to have been granted to the petitioner from the date of completion of the course, that is June 2006.
Obliged to get.
But then it is 1st January 2006. Is
It is from June 2006. It will be.
No, in page number 52, it says that since you have not passed on 1st January 2006.
Because notification as other thing was there with effect from 1st January 2000.
Oh.
After 2006.
Mr. Prosenjit, Mr. Vishwarup বিশ্বাস, learned advocate appearing for the petitioner submits. You have gone through the submissions. of the last order. This is what you are submitting.
Obliged, my lord.
Fourth record করবো না submission.
ওটাও same ছিল।
একদম
রিজেক্ট করেছে এটা দিয়ে আমার 26 তারিখ ওটা
2005
হ্যাঁ ওটা 25
Mr. Bishwabroto Basu Maulik, learned advocate appearing for DPSC Hooghly, submits that the petitioner is similarly circumstance as of Bishwanath Das. ওনার সাবমিশনে বিশ্বনাথ দাসের এটা রেফার করবে।
জুন থেকে
Mr. বিশ্বাসের সাবমিশনে to buttress his contention, it relies on the decision in Bishwanath Das versus State of West Bengal WPA 14665 of 2025.
জানুয়ারি মাস থেকে দেবাংশুদা চালু করে দেবে খবর হচ্ছে অনলাইন
Rest same. Learned advocate, Mr. Birjendra Pratap Singh, learned advocate for the state, leaves the matter to the discretion of the court. The rest same
আমার ওইটাতে সব হয় নিয়ে
from
দেখা
June 2006 যা আছে,
এটা আছে না একটা
the authorities are further directed to
সব হয় নিয়ে আমার দেখা হ্যাঁ foldable হাতে করা যায়
extend all consequential benefits to the petitioner.
তখন ওটাতে সব হবে আমার দেখা দাও
Further, the concerned authority directed to take necessary steps in view of observation made herein above within a period of 2 months from date of communication. Disposed of.
get finished that would be more that is
All consequential, all
everything we will
what
get
you
in
have
one
not read
petition.
also in consequential benefits, that is.
because I have faced something.
আর পরেরটা
Oh,
Well, next item also same.
let me come back up.
Well, there are two matter fixed. Well, I have to go to my Justice Chattopadhyay because pass over matter. Only page 30 kindly take same order will be. It will be from 2001. Only change will be there.
You take it next week,
Next,
next day.
well, kindly take make it pass at 2 p.m. and I'm coming from there.
ঠিক আছে, বুঝছি।
I'm coming.
প্রদীপ আছে তো করে
No, no, একই। I'm so grateful.
গেটফুল
Thank you.
The last occasion in Lordship was pleased to issue rule.
Item number 2, my lord, I am appearing on behalf of the contemner number 1, my lord. My lord, I am come out for my professional work at Circuit Bench, Jalpaiguri. My lord, I am paying for 2 days accommodation. If your lordship kindly consider that I am paying for unconditional apology, my lord.
Where is the contemner?
My lord, today I am out from station, my lord. My lord, I am today at Jalpaiguri Circuit Bench, my lord. I am paying for unconditional apology, paying for 2 days accommodation only, my lord.
That is your personal ground. Where is the contemner? The rule was issued upon the contemner.
My lord, contemner has already been started the proceeding as per your lordship order. Your
Where is
lordship,
she? Where is the contemner?
my lord, I will produce contemner next day, my lord. If your lordship kindly consider, my lord. My lord, we have already
Why
been.
do you advise your client that he or she has to appear as per your choice? When the rule has been served upon the alleged contemner, why she has not appeared?
My lord, I am paying for unconditional apology, my lord. Please consider, my lord. Only 2 days accommodation, my lord. Please, my lord,
Peruse the report of the Deputy Registrar Read dated 1st July 2026. As per it appears from the aforesaid report that the rule has been received by one Agomoni Ghosh, Sahayak attached to Putsuri Gram Panchayat on 17th July 2026. Learned advocate appearing for the alleged contemner seeks accommodation. Not one, actually, the contemner. There are 2 contemners. No, only one.
Shubabachi.
Seeks accommodation. And also ensures that the alleged contemner shall remain present on the returnable date. Assure. Assures. With the assurance that the alleged contemner shall remain present on the returnable date. Next weekend. 4th August, 2 p.m. 4th August, 2 p.m.
Deeply obliged, my lord.
The alleged contemner remain present on that date.
Deeply obliged, my lord.
My lord, I am for the alleged petitioner, Your Lordship. Last occasion, Your Lordship directed to serve upon the alleged contemner. So, order dated. My lord. This is, my lord, my affidavit of service. My lordship.
Compliance?
My lord, the alleged contemner is present in person, my lord. My lord, we received the brief yesterday, and I have gone through the brief, my lord. There has been an inadvertent error on the part of the alleged contemner, my lord. He has not complied with the order. My lord, but the inspection is done, and he tried for mediation, my lord.
Who was directed him to mediate? He was asked to hear the parties.
My lord, I know, my lord. My lord, there has been an inadvertent error on his part, my lord. I apologize for his conduct, my lord. The only thing I'll pay before your lordship, my lord, is kindly gives us 2 weeks time, my lord. We'll comply with the order. My lord,
the alleged contemner, what is his name? Dulal Mollik is present in court. Learned advocate representing the alleged contemner seeks 2 weeks accommodation to comply the order of this court and file affidavit of compliance. 11th August 2026 at 2 p.m. Alleged contemner is directed to file affidavit of compliance on the returnable date. Where is he? The appearance of the alleged contemner is dispensed with for the time being. You file it along with the affidavit of compliance. Give a notice to all the parties. Yes. Vote হয়ে গেছে না?
Same as item 10. Exactly same date also.
10
Page
কি
30
dictation
kind-
ছিল গো?
page-
প্রথম 10 একটা ওটা বলা আছে না, দেখবেন ওই লেটারটা যেটা আছে না, ওই লেটারটা সেট অ্যাসাইড করতে হবে। ওইটা বলেছি কিনা জানি না, বলিনি না? In 10 there is one addition also, that is that letter that has been issued that you are not entitled, that is to be set
Set
aside.
aside. I am so grateful. I thought it during the recess.
ওটা একটু এন্ট্রি করে।
Yes, one line to be added. Here also, annexed at page 47.
বলে দেবো।
And another change will be here, transferred to assistant teacher of a school instead of headmaster. They are headmaster.
Others are same.
Yes. They are headmaster, here assistant teacher. And date of retirement is the changing date.
Same course he has completed. Same 2005-6.
Yes, yes. Can you take page 31 page? 2006.
ওইটুকু চেঞ্জ করে দেবেন।
Page 31. Certificate given 2006 examination. Same date. I have checked it up, my lord. And only date of retirement will be changed.
Date of retirement will be here.
Here, my lord, kindly take 30th of September 2025. And
30th
there
September
February
2025.
or January 26.
বাকিটা same.
My lord.
Disposed of.
My lord.
Here any letter has been issued that he is.
Yes, page 47, overdwell due to non-allotment of a category. Page 47, right-hand side column, overdwell should be deposited. That is the impugned.
You have deposited.
No, I not. That is the communication made. I come before you.
25th February 2015.
This is my lord 18/12/2025 issued. Assistant Director, bottom.
Page number.
Page number 47.
So 47 is a letter dated 25th February 2015.
My lord, kindly take 18/8/25 it is.
18/8/25. Okay.
My lord, subject to correction. Bottom is এটা 25 আছে. Right hand side হলো 25 written.
18th August 2025 is set
এটাও
aside.
25, এটাও 25. Set aside. My lord.
Cancel.
I'm so grateful.
Thank you.
I'm so grateful. Not affidavit of service. Before moving the matter, everything I have to check it up before submission. What is my duty? ট্রান্সফার টু অ্যাসিস্ট্যান্ট টিচার হবে, হেডমাস্টার হবে না। এটা হেডমাস্টার ছিল, এটা তো হেডমাস্টার হবে না, অ্যাসিস্ট্যান্ট টিচার হবে। আর ডেট অফ রিটায়ারমেন্টটা চেঞ্জ হবে। অবলাইজ ছিল, অবলাইজ, কারেক্ট।
Yes.
Petition, my lord. I am petition.
What is this thing?
My lord, this one, my lord, say, my lord, is the husband of the my lord, deceased employee. My lord, the employee, my lord, the husband is not paying for family pension on the ground, my lord. The employee, my lord, opted, my lord, under my lord 1980, 1990, 1990, 1998, my lord,
Rupa 1990 opted.
opted.
Now you're
Sorry,
want
my
to
lord,
deposit that.
my lord.
You want to deposit it.
No, deposit. No, I have paid I have made application for depositing the same, but no response there.
Contributory Provident Fund you
No,
intend to deposit.
My lord, I want to deposit. Application, my lord, pays.
You are the widow,
My lord, husband of the widow.
widower.
Widow, sorry, my lord. Husband of the, my lord, deceased employee, my lord, female employee, I am the husband. My lord, page 22 is the, my lord, documentation. Your lordship, my lord, judgment is there, my lord. I have annexed the same.
In which paragraph you have stated?
my lord.
that he has exercised ROPA 1990 and 90.
Paragraph 6, my lord.
Yes.
Representation, page 22 is representation.
Petitioner's husband, it will be not petitioner. Petitioner's wife, no?
Petitioner.
Yes.
My lord, we have to take instruction, your lordship.
My lord, here lordship, this is there, my lord. I have annexed the order, my lord, page 28, my lord. Your lordship. No, yeah, page 20,
20,
my lord,
33,
20, my lord, 20,
33.
my lord. Page 33, my lord. Lordship, direction is there, my lord, is my lord. Well-known direction to all.
Affidavit of service give there. Next we will see.
Yeah.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities to permit the petitioner to deposit the employer's share of contributive provident fund in order to avail the benefit of pension, family pension. The Brigadier Pratap Singh, learned advocate for the state, respondent seeks accommodation to take instruction.
Copy has been received by you.
Next, please this matter next week. Next week.
Next week. Lord, the date be fixed, my lord. Next week. Huh? Oh, grateful. Grateful.
13-minute app.
But the petitioner is a headmaster, my lord, who has retired from service on attaining the age of superannuation with effect from 31st March 2026, my lord. But the pension application was submitted. Thereafter, my lord, the objection was raised. But thereafter, my lord, the rectified copy of the pension application was submitted. But till date, my lord, nothing has been disbursed, my lord. At least the provisional pension may be disbursed, my lord. The 31st March, my lord, I have retired, my lord. But the
31st March 2025.
2026, my lord. But nothing has been disbursed, my lord. The gratuity, my lord, the provident fund, as well as my lord, the monthly pension also I am not getting, my lord. My kindly see, my lord, my application page 58. Pension.
When did you first submit the documents?
My lord, 26 May 2025. That was submitted by the authority. Thereafter, my lord, the rectified pension application also was submitted on 25th March 2026, my lord. Page 61, my lord. Last annexure, my lord. But last date of service, my lord, 31st March, and the application was submitted sub-inspector of school by 25th March 2026, my lord.
You and Kachira 196. Teacher. Where is the objection?
No objection has been communicated, my lord, but
But you
in
have
the-
written JDA objection application number such and such.
but it was not communicated, it was submitted, resubmitted by the department, my lord. But the rectified copy was itself submitted by the
DI, District Inspector Schools.
district inspector schools.
JDA.
But petitioner, my lord, was appointed with
Here for?
For the state.
but petitioner was initially appointed in on 31st October 1995, my lord. But with BA B.Ed qualification, my lord. And the by notification dated 4th March 2013, my lord, page 28, my lord. But my lord, the page 28, my lord, clause 6, my lord, where it was mentioned, my lord, the teachers appointed 1st July prior to 1st July 1996, my lord, that is in my case, my lord, applicable in my case, also obtained B.Ed qualification. I was appointed with B.Ed qualification. May be released A category scale of pay. My lord, I was treated as a 10 category teacher, my lord, all along, my lord. But now, my lord, my pension is withheld, my lord.
Let them file a report.
At least my provisional pension may be disbursed, my lord. Otherwise,
Let us see.
my lord,
In short, next week we get a report from the state why this
as
has
it
been withheld.
as it.
By the present writ petition, the petitioner seeks for disbursement of pension and other retirement benefits in favor of the petition. Seeks direction of respondent authorities. Proper affidavit of service. Mr. Ronindo Bose, learned advocate for the petitioner, submits that the petitioner joined as an assistant teacher
Fine.
in Kachara Dokkinpara Primary School, District Hooghly, under Hooghly District Primary School Council on 31st October 1995. Subsequent thereto, petitioner was appointed as head teacher of Saraswati Primary School. Same.
No, my lord, head teacher in Purbo Thakurani Chowk, Saraswati Primary School.
Thakurani Chowk, Saraswati Primary School, same DPSC.
Yes, my lord, Hooghly.
Under Hooghly DPSC Hooghly. The petitioner superannuated on on the prayer of learned advocate. Who is there?
Mr. Basu Malik is mentioned.
কি মা পেনশন
Pension.
বলো রিপোর্ট দি আমি জেনে নেবো
On the prayer of learned advocate for the petitioner, leave is granted to implead District Primary School Council as added respondent number
Respondent numbers.
Added, yes, my lord.
learned advocate for the petitioner directed to the copy
Yes,
of the
my lord.
writ-
Copy has been given.
copy of the writ petition and its annexures is handed over to learned advocate for DPSC Hooghly. Superannuated on
But 31st March 2026.
31st March 2026. However, till date, the pension and retiral benefits have not been disbursed to the petitioner. Learned advocate for the state seeks to file a report. DPSC will be required to file any report?
No, my lord,
State is
DI is the
DI is the, my lord.
DI and DPPG.
let such a report be filed
DI দিলে DPPG
by the returnable date. Please this matter. Next week you get a report. Please this matter on date what? Next week.
এটা তুলে দে এটা লিস্টে তুলে দে হ্যাঁ না রাখলো কবে রাখলো কালকে নেক্সট লিস্টে তুলে
Service.
ফেলে দিন তো। কোথায় ডাস্টবিন আপনাদের আছে?
ও রানী
Yes.
But the matter relates to grant of interest on arrear family pension amount. Well, husband of the petitioner was an assistant teacher, assistant primary teacher, and he died in harness. Well, thereafter, the petitioner applied for family pension, but that was not granted. That's why petitioner filed a writ petition. My lord, kindly come to page 18. And this said writ petition, page 18. Or said writ petition was disposed of in favor of the petitioner, directing the authorities to extend the benefit of family pension in terms of GO dated 12 July 2011. But after that, my lord, the DPPG raised some objection in pension file of the petitioner. Now to page 26, page 19, my lord, next page. And challenging the said objections, my lord, petitioner again filed a writ petition. And same was disposed of on 28th June 2016, starting from page 20. And the operative is at page 25. Page 25, last paragraph. This honorable court was pleased to direct the authorities for extending the benefit of family pension in favor of the petitioner. And against this order, my lord, the state preferred an appeal before the division bench. My lord, kindly come to page 27. Said appeal was dismissed on merit. My lord, the operative part the appeal was rejected, paragraph 9, page 31. And thereafter, my lord, page 32. PPO has been issued in favor of the petitioner, page 32. Granting family pension in our favor with effect from 1st April 1981.
Arrears have been paid.
My lord.
Arrears paid.
And pursuant to this PPO, my lord, arrears has been paid.
When?
Arrear has been paid, my lord, on in 2026, 6th April 2026.
6th April.
6th April. And I am praying for interest on arrear.
My lord, in my most humble submission, my lord, this is not admissible in this case. My lord, if it was a case of, my lord, mere, my lord, pure case of administrative latches or the fault on the part of the department, my lord, that would have been admissible. But, my lord, in the case of, my lord, here, where there was 2 rounds of litigations, my lord, and in the second, my lord, the appellate court order at page 28, my lord, will be pleased to take paragraph 5. My lord, here, my lord, page 28, my lord, of the writ petition, my lord, paragraph 5, my lord, the extracted portion which is set out, my lord, from the 2014 order, my lord, it says last 3 lines I'll trouble my lord with. Memo number such and such, my lord, it is however made clear that the benefit of the said scheme shall accrue in favor of the writ petitioner strictly in terms of memo number such and such, dated 12 July 2011, issued by School Education Department, Government of West Bengal. My lord, they are claiming, my lord, from 81. My lord, if it was done in terms of the 2011 memo, in any case, my lord, 81, my lord, is not admissible. My lord, pursuant to directions of this honorable.
When did he die? When did my husband die?
My lord, husband, my lord, he died in 71, my lord. 31st August 1971, my lord. My lord, there, my lord, due to thunderstroke. My lord, now if, and my lord, in any case, this should have, I'm sorry, my lord, this should have been, my lord, directed by the courts which granted, my lord, them, my lord, family pension. There, the court did not say that pay along with interest. My lord, they'll have to produce the writ petitions whether there was a prayer or not. If it was a prayer, my lord, asking for interest, and that prayer was not granted, my lord, that issue is settled. That stands res judicata. My lord, if there was no prayer, then, my lord, perhaps, my lord, we will again, in my most humble submission, even that is not admissible. If there was a prayer, my lord, for granting all arrears, all dues, all benefits along with interest from 1981 or whatever date, my lord, and that order was not passed in their favor, my lord, in this case, but in any case, that will not be admissible. So, my lord, and also after these 2 rounds of litigation, my lord, at best, my lord, worst case scenario, my lord, from 2025 when this last order came and till my lord 2026 when this disbursal was done, my lord, perhaps my lord, there can be something, my lord. My lord, looking for a reasonable period after that. My lord, the courts have to direct. The courts have said that yes, grant them all retirement dues and benefits. And at the second stage also, when they came up, my lord, before the Honorable Division Bench on 2nd September 2025, my lord, the order is at page 27. My lord, even then that court did not say.
Yes.
My lord, even the order of the writ court, my lord, did not say that. My lord, the order of the writ court should have said, my lord, at least. My lord, since that was not done, my lord, in this case, my lord, if it was a case of, my lord, mere pure administrative latches on the part of the department, my lord would have been pleased, my lord, to extend my lord's hand. My lord, in this case, my lord, in my most humble submission, my lord, this is not admissible, my lord. Otherwise, my lord, this will open, my lord, dangerous floodgate, my lord, where even after filing cases, orders have not been allowed in those cases, interest has not been granted. Then, my lord,
similar cases also, my lord also passed similar judgment, my lord, granting.
my lord, this I am submitting, my lord,
Where is
on
that? Earlier writ petition, you say that there was a prayer of interest,
No, my lord,
various and
there was no prayer for.
I do not know, my lord. That is not again before my lord or before my us, my lord. If it was a prayer, my lord, and that was not granted, my lord, that stands res judicata, my lord.
In earlier writ petition, there was no prayer for.
My lord, I will have to, my lord, I'm not even using any report in this case, my lord. I'm making submissions only on the points of law. My lord, if it was a case of report, my lord, I could have come back, my lord. If I am able to satisfy, my lord, on the points of law, perhaps, my lord, I may not be even be required, my lord, to use a report.
Okay.
So, my lord, because we've also not perused the, my lord, the earlier writ petitions. What was the prayers made in those writ petitions? My lord, because in general, all these writ petitions carry a prayer for interest, my lord. That's what, my lord, we've seen.
Find out from the writ petitions whether there was earlier prayer for grant of interest or not.
My lord, will it be my lord's pleasure, my lord, to direct them to produce them, my lord?
They will produce it. Which writ petition?
My lord, there is a 2014.
2014. That was
2014. 2014, my lord.
2016.
2016.
So produce the copy of these writ petitions.
And my lord,
Appeal is followed from the order passed in 2016.
my lord. My lord.
2016.
So
2014, 2016, my lord, they can. My lord, at best, my lord, what is the
produce the earlier litigations and we'll examine the prayers therein. Thereafter, we'll see.
Then we'll see, my lord. On the other points of law, my lord, I have not addressed, my lord.
Service filed on behalf of the petition is taken on record. Mr. Loknath Chatterjee, learned advocate for the State Submits Act. The earlier, this is third round of litigation. Whether the petitioner has prayed for grant of interest in the earlier round of litigation needs to be examined. Accordingly, the learned advocate for the petition is directed to produce the copy of the writ petitions being WPA 14131W of 2014, WP 5622W of 2016, and the copy of the Memorandum of Appeal in MAT 150 of 2020.
Memorandum was preferred. Appeal was preferred by the state.
State.
My lord.
Oh. Then state you can produce that.
But I do not know, my lord, whether these old records.
Find out whether you made in. Oh, this was not the matter organ. Because we are challenging that 2016 order. So there is no question of any.
Yes, my lord.
In the earlier two litigations, whether he prayed for any interest.
That is one point, my lord, which my lord will be pleased to examine.
Please this matter on 2 weeks for reckoning.
Under the
11th August. 11th August. Under the same heading.
Under the same heading, top, my lord.
Yes, next.
Yeah. 15, my lord, I am for the petitioner. Matter relates to grant of family pension. It is second time.
Advocate appearing for the video service. Pension Sanction Authority has already recommended to grant to family payments in harmony as it thanks. Yes, what is the reason?
My lord, I informed to the respondent authorities, but they supply this week.
Apply?
They supply instruction this week.
Where is that?
No, my lord, they do not supply. They told me that they will supply this week.
Ms. Wenzel, an advocate appearing for the state, seeks accommodation. It submits that the instruction has not yet been received from the concerned department. She seeks accommodation. 11th August.
Same heading.
Same heading, 11th August.
I appear on behalf of the petitioner, my lord. Activity service. আমরা পাঠিয়েছি petitioner is Dap and Dam. Petitioner father was assistant teacher and PP was issued 1990, 14th May. Thereafter
1990
14th May.
in favor of the father.
Thereafter smoothly getting his pension. Thereafter petitioner father died on 24th September 2006. Annexure P1.
May 1990.
Died on 24th September 2006. And
24th
petitioner mother was died before father. He died on 5th January 2006. 17, page 17.
5th January. 5th January.
Primary.
There-
It
2006.
was issued 14th May 1990.
Okay.
Thereafter, petitioner is Dap and Dam, physical handicap certificate page 20, annexure P3.
Yeah.
And thereafter, my lord, apply annexure P5.
Page bolo.
Page 28.
Page 28 কি বলছো?
Page 20. Annexure P5, page 28.
Oh.
Submission of pair of Sri Osit Podia, son of late Sonatan Podia, ex-assistant teacher, Hatipara Pariyapal Primary School, under Topsha Circle for the lifetime family pension to the physically crippled, disabled son of late deceased teacher. And in reference to the above noted subject and geo number under reference, I
11.
beg to submit
2011.
9 memo number 788 dated 9th June 2011.
Then
Thereafter, my lord, representation filed before the concerned authority and no steps taken till date. Thereafter, file representation for pension, getting pension and area, but no, thereafter page 34, annexure P7. I read it, my lord. A letter of claim of family pension, arrear family pension in favor of Sri Osit Kumar Podia and in respect of late Sonatan Podia has been received by this office 16th March 2026, where you have applied and inter alia stated as Sri Osit Kumar Podia, a physically crippled, disabled son of late Sonatan Podia. Whereas the applicant signed the left thumb impression by Arun Kumar Podia, which created an ambiguously at first. In fact, it is not clear about the claim and claimant, but it is crystal clear from your attached copy of forwarding letter. District Inspector School, Primary Education, Paschim Medinapur, provide its letter number 788 P, pension dated 9th June 2011, which provide that the claim of family pension in favor of Sri Osit Kumar Podia had already been forwarded to Director of Pension Provident Fund and Group Research, DPPG, West Bengal for long ago. So you are requested to communicate this District Inspector School, Primary Education, Paschim Medinipur, from where your claim had been prepared and forwarded to DPPG, West Bengal. Moreover, no relevant documents are available to this office for establishing your claim in the reason that during the material point of time, this office has not come into force or become a pension sanctioning authority, being a newly constituted district. District bifurcation 2017. In view of the above, you are hereby requested to make all sorts of communication with District Inspector School Primary Education, Paschim Medinipur, for establishing your claim query in future. This is for your information. This is my last position, my lord. Thereafter, I filed this writ petition.
Yes.
It was long back in the year 2009, my lord, the District Inspector of Schools, Paschim Medinipur, has sent the papers to the, my lord, Deputy Director of Pension Provident Fund and my lord, Group Insurance. But my lord, thereafter, after a lapse of 15 years, he has not taken any step, and after a lapse in the year 2026, he has filed the at page, my lord, 29. My lord, prayer for grant of family pension. I think this is the delay occurred by the petitioner ought to have taken step in the when it was sent, and nothing was done in these 15 years, and subsequently, my lord, therefore, my lord, the claim of the petitioner, it was sent to the deputy director. That is, the state authority can apprise your lordship regarding this one. But my submission is that long delay by not claiming in time, this is the whole difficulties, and for which the petitioner is responsible. He ought to have taken some steps by giving remainder, by taking steps that yes, I am not getting, and my lord, this is the whole situation. Yes, it has been cropped up, my lord, due to the negligence. And yes,
State government, my lord.
no negligence in
now
the what you are doing for
Relied upon
15
one
years.
judgment, lordship judgment.
That is there.
Kindly, take up this lordship judgment.
Regarding the delay, I am paying before your lordship. Delay has been
Supreme Court judgment.
delay has been occurred due to his
Supreme Court
latches. He ought to have taken some steps,
Supreme Court
remainder,
judgment.
or before the my lord,
No applicant for
DPPG or my lord, before the appropriate authority. After a lapse of 15 years, he has filed this application.
Supreme Court cases 2008, page 648. Union of India and others versus Tarsam Singh.
Affidavit of service filed on behalf of the petition state.
But
what is your instruction?
My lord, we have to take instruction here, lordship, just
So why from 2011 it says that this has been forwarded to the DPPG, but they have not sanctioned the family pension? What is the reason? By the present writ petition, the petitioner seeks direction upon the respondent authorities for grant of family pension in favor of the petitioner being an unemployed, physically handicapped son of the deceased pensioner.
Judgment আছে দিলে একটু কপি করে দিয়ে দিই যদি একটা
Mr. So and so learned advocate for the petitioner submits that the father of the petitioner was late Sanatan Paira.
Poira.
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 PAIRA, how do you say? PAIRA was an assistant teacher of Hati Pata Hariparia Primary School under Gopi Vallabhpur, Tapsia Circle, District Medinipur.
Yes.
Who retired from service on superannuation on which date he retired?
Return physically incapable, my lord, invalid person 1984. Page 18, as 30th June
30th June
1984.
30th June 1984. His father was medically invalid to
Yes.
continue service due to invalidation.
Invalid.
Medical invalidation.
Medical.
Pension payment order was issued on 14th May 1990. The father of the petitioner died on 24th June 2006. The mother of the petitioner predeceased his father and died on 5th January 2006. On when did you file the application? Date of application.
Date of application, my lord. 6th March 2026.
When did you file your application seeking for family pension?
He has not stated in the petition, my lord, when he has filed.
Subsequent thereto, petitioner made an
First-
application seeking for grant of family pension, being a disabled son of the deceased employee. Although in the year 2011, the District Inspector of Schools, P.E. Medinipur, forwarded the papers of the petitioners to the Director of Pension Provident Fund and Group Insurance, Government of West Bengal, no steps have been taken. After a long lapse, on 6 March 2026, the petitioner made a representation and a reply was received from the District Inspector of Schools Primary Education, Jhargram. However, till date, no family pension is granted. Hence, this writ petition. State seeks to file report. Mr. Ranjan Sahal, an advocate for DPSC, Jhargram.
Paschim Medinipur and Jhargram.
Paschim Medinipur and Jhargram submits that there is inordinate delay on the part of the petitioner in raising his claim.
And there is no explanation in the writ petition.
Which has not been explained in the writ petition. Mr. State seeks accommodation to seek proper instruction. 11th August.
11th বললেন 11th August. Deeply authorized, my তুমি একটা রিপোর্ট নিয়ে আসো আমাদের তো সেখানে কিছু বলার নাই দেখবো ওগুলো ঠিক কি না ভুল। ঠিক আছে
Hearing.
For the petition.
तो कॉपी तो मेरे पास था तो कॉपी मेरे पास था proceeded copy comment.
My lord, this is with regard to the selection process of the primary school teachers in the year 1986-87 of the district of Howrah. In the year 1987, written examination was held, but due to irregularities and some omission and commission, interim order was passed by the Honorable Court not to give effect of the written examination. Ultimately, in the year 1993, interview was held. The petitioner was given appointment in the year 2003, he joined on 16/4/2003. So I have to show the irregularities which has been observed by the division bench, for which this delay has caused, my lord, with the same selection process. Page 43.
क्लेम नहीं किया 2014 में वो मर गया
Relevant portion, my lord. I am reading, my lord. It is a big judgment, my lord. Page 43 of the judgment started, my lord. P2. My lord, on 4th April 2002, when the matter came up before this division bench, we directed one Mr. Shubhankar Sarkar, Assistant Director of School Education, to prepare a fresh panel on the basis of the marks obtained by the candidates in the selection which took place in 1993 and produce the same before this court by 20th May 2002. In pursuance of that, a report was submitted by the Assistant Director of School Education, wherein he has submitted that after going through the score sheet prepared in 1993, he found some corrections and overwriting. My lord, then, my lord, skip over, my lord. I am coming to bottom, my lord, the relevant portion. He further reported that, my lord, 10th line from the bottom. He further reported that during the course of scrutiny of score sheets, my lord, got it, my lord. He further reported that during the course of scrutiny of score sheets, it was found that good numbers of candidates came within the zone of consideration in the fresh panel. Their names were not in the earlier panel. As particulars regarding qualification and date of birth was not available, PNA is marked against them. He also found that marks
PNA?
PNA, my lord, I also do not know, my lord, what is PNA. He also found that marks has been given to some of the candidates on Bhaibabosi, but no marks were awarded by the members of the selection committee on academic qualification. Therefore, from the latest report given by the Assistant Director of School Education, it appears that there are some omission and commission in the selection made in the year 1993. So, my lord, these are the irregularities observed by the division bench, my lord, for which, my lord, litigations after litigations and counter litigations cropped up. This matter went to the Honorable Supreme Court thrice and again remanded back. My client, my lord, though joined on 16/4/2003, petitioner's husband, my lord. I am here, my lord, wife has come, my lord. Petitioner's husband joined, my lord, on 16/4/2003 and date of retirement, my lord, on 28/2/2011. shortfall, my lord, 2 years, 2 months, 27 days. With the same selection process, my lord, 2 division benches, one presided over by the Honorable Justice Homensen, and another division bench presided over by the Honorable Acting Chief Justice Tabobrata Chakraborty. My lord, has allowed minimum pension to those 2 persons, my lord. One Vishwanath Dolui. My lord, I have to, my lord, kindly, if you lordship, kindly take the exception, my exception, my lord.
Yes.
Page 44, pension payment order issued. Page 44, my lord.
Yes.
Page 44, my lord, Bongshubodhan Kole, my lord.
एक्सेप्शन का 44 बोल रहा है क्या?
Employee name at the top, on the left side, left hand side.
Yes.
Qualifying service, my lord, 6 years, 4 months, 23 days.
Where it is qualifying? Yes.
Qualifying service. Six years, 4 months, 23 days. And
this is after the order was passed by the school.
By the division bench.
Division bench.
I shall show the order of the division bench, my lord, before you lordship, my lord.
It's 44.
Next page, page 44 and 45, another PPO, Vishwanath Dolui. Page 45.
4 years.
My lord, qualifying service, 4 years, 8 months, 16 days. PPO has been issued in favor of these 2 persons, and the 2 division bench, my lord, judgment, I have to show before you lordship. Page 18, my lord, single bench judgment, then my lord, we can page 18. My lord, participated in the selection process initiated in the year 1986, my lord. Page 18, my lord. Exception.
You see, it is 1993.
My lord.
The election process of 1986 or 1993?
93 interview was held. 1986, 87, written examination in selection process started. My lord, may I show the single bench judgment, my lord? May I read, my lord?
Yes.
The petitioner is a retired primary school teacher. He participated in the selection process initiated in the year 1986. Appointment letters in connection with the said recruitment process were issued to the successful candidates in the year 1993. Even though the petitioner secured more than the cut-off marks, appointment letter was not issued in his favor. A series of litigations followed. In the year 2002, the Honorable Division Bench of this court was of the opinion that the candidature of the candidates who secured more than cut-off marks should be re-examined. Ultimately, appointment letter was issued in favor of the petitioner in the year 2005, and he joined on 8/6/2005. He retired from service on attaining his normal age of superannuation on 31st October 2011. After rendering 6 years, 4 months service. As the petitioner did not serve for the qualifying period for receiving pension, he was held not eligible to receive the same. In the present petition filed in the year 2023, the petitioner prays for a direction upon the respondent authorities to grant notional benefit to him, as candidates who secured lesser marks than the petitioner were given appointment when the petitioner was not. Reliance has been placed on the judgment delivered by the Honorable Division Bench of this court on 31st October 2019 in the matter of Ashim Kumar Chakraborty versus the State of West Bengal and others, wherein the court was pleased to condone the shortfall in the qualifying service period on the ground that the delay in issuing the appointment letter was not attributable to the employee. The petitioner prays for similar relief. Learned advocate representing the state respondents opposes the prayer of the petitioner. It has been submitted that the petitioner has approached this court after a long delay. At the time of appointment, petitioner was aware that he would not be able to complete the qualifying service period for receiving pension. But he did not raise any issue at that point of time. More than 11 years after the prayer for grant of pension was refused by the authority, the instant petition has been filed. Prayer has been made to dismiss the writ application on the ground of delay alone. Reference has been placed on the order dated 2nd May 2022, passed by the Honorable Division Bench of this court in amity number 288 of 2022 with IA number K1 of 2022. Sri Somernath Pal and others, and the State of West Bengal and others, wherein the court refused to extend notional benefit in favor of the employee who could not achieve the qualifying service period. Reliance has also been placed on the order of the Honorable Supreme Court dated 1st November 2022 in petition for a special leave to appeal such and such in the matter of State of West Bengal versus Sumohan Mandal and others, wherein the court clearly specified that the judgment and order passed by the High Court on 11th April 2022 in amity number such and such in the matter of the State of West Bengal and others versus Sumohan Mandal cannot be cited as precedent. I have heard the submissions made on behalf of both the parties. The court is not inclined to accept the submissions of the respondent authority for dismissal of the writ petition on the ground of delay. Admittedly, in the instant case, the delay has not affected the right of any third party. The Honorable Supreme Court in Union of India and others versus Tarsim Singh, 2008, Volume 8, Supreme Court Cases, page 648, laid down that where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy, with reference to the date on which the continuing wrong commenced, if such continuing wrong creates a continuing source of injury. The Honorable Division Bench of this court in the matter of Ashim Kumar Chakraborty, Supra, held that the respondents cannot be allowed to take advantage of their own wrong. Here, it cannot be denied that the respondents delayed in issuing the appointment letter in favor of the petitioner, even though the petitioner scored more than the cut-off marks and the candidates having marks less than the petitioner were given appointment. Had the respondent authorities issued appointment letter in favor of the petitioner in proper time, the petitioner would have certainly served the entire period of qualifying service, qualifying him for receiving pension. The petitioner had to fight a series of legal proceedings to protect his right, and ultimately appointment letter was issued in his favor in the year 2005. When in respect of the others, the same was issued in the year 1993. The petitioner did not receive any salary for the period from 1993 till 2005, not allowing his prayer for condoning his shortfall in his qualifying service period will amount to double jeopardy. Neither did he receive his salary for the period he did not work, nor will he receive his pension after his retirement for no fault of him. The petitioner ought not to be deprived of his legitimate claim to receive pension. The District Inspector of Schools, Howrah, is accordingly directed to grant notional benefit to the petitioner by treating him to be in service for the qualifying period of 10 years. The District Inspector of Schools, Primary Education, Howrah, is directed to proceed processing with the pension file of the petitioner and ensure that the petitioner receives his pension at the earliest, but positively within a period of 4 months from the date of communication of this order. It is made clear that the petitioner will not be entitled to salary for the period for which he did not work, and will also not be entitled to any interest for the delayed payment of pension. He will only get the benefit of 10 years in service. The writ petition stands disposed of. The State of West Bengal preferred appeal. My lord, the appeal order, page 25, my lord, of the exception. My lord, may I read the present appeal, my lord?
This was confirmed in the appeal court.
The present appeal has been preferred by the state and its functionaries, challenging an order dated 5th August 2024, passed by the learned judge in the writ petition being WP number such and such. As we have invited the learned advocates to advance their arguments on the merits of the matter, the delay in preferring in the present appeal is condoned, and the application for condonation of delay is disposed of. Records reveal that the writ petition being WPA number such and such was preferred by the writ petitioner, respondent number 1, herein namely Bangshubodhan Kole, challenging inter alia an order dated 18th April 2012 passed by the Principal Secretary, School Education Department, Government of West Bengal, refusing to condone the deficiency in qualifying service of Bongshi and denying him pension on a purported finding that he had served less than 10 years, which debars him from such benefit.
Page 28. 28 is the finding of the appeal.
Yes, ma'am. Yes, ma'am.
Similarly, the court
Page,
has also
page 28.
Delay will not hamper the right of the petitioner as per Tarsem Sim.
Yes, ma'am.
Yes.
Page 28. My lord.
No, that has been affirmed.
Yes, my lord. Bongshi's approval was withheld due to a series of litigation and was ultimately granted in the year 2005, when in respect of others it was issued in the year 1993. Though such delay is not attributable to Bongshi, he had suffered the injury for having been deprived of approval for more than 10 years, and that as such the state cannot set up any defensive doctrine of estoppel. Here, my lord, division bench, my lord, observed regarding the estoppel. The beneficent scheme would be thrown out of gear in the event a restrictive meaning is applied and benefits are not extended to Bongshi. Delay on the part of Bongshi in approaching the court, as urged by the appellants, was rightly discounted, placing reliance upon the judgment delivered in the case of Union of India and others versus Tarsem Singh, reported in Shas and Shas in appreciation of the continuing wrong, creating a continuous source of injury, and more so when the grant of pension upon condonation of deficiency in service would not in any manner affect any settled right of third parties. In view thereof, we do not find any reason to interfere with the direction of the learned judge to grant notional benefit to Bongshi, cheating him to be in service for the qualifying period of 10 years, and to proceed processing with the pension file, and to ensure that he receives his pension at
the order.
My lord.
The order of single judge has been modified. The direction has been given to the principal secretary.
Principal secretary. So, my lord, so the division bench presided over by the Honorable Justice Somensen also dealt with this case. Page 33, my lord. From the single bench, The state has preferred appeal of the exception.
Same recruitment process.
Same recruitment process. Same recruitment process.
Okay.
डिपार्टमेंट का exception. उसी का तो exception दिया है.
This will
My
go
lord.
for the secretary. Another is Bongshi Bodhan, another is
Vishwanath Dolui at page 33.
36. Nokul Chandra Das is also there.
My lord. Same selection process. Thought follow more than 3 years.
Yes.
In my lord, Vishwanath Dolui, it is more than 5 years, my lord.
When did this person join in service?
My lord,
2003.
2003.
3.
2003.
16th April 2003, retired from service on 28 February 2011. Thoughtful 2 years, 2 months, 27 days. When the state, my lord, has already issued pension payment order.
The husband of the petitioner was a petitioner in the earlier writ petition where this irregularity was detected.
No.
Page 32.
Page 32 of the writ petition, my lord.
Petitioner number?
Serial number 8.
The serial number is Basudev.
47 C. Joy Narayan Jana. Husband's name.
Sri Joy Naran, yes.
Jana, yes.
But this is appeal.
Appeal.
I mean, the writ petitioner, he was not the writ petitioner?
No, he.
Page 32, my lord.
32.
32, my lord. Serial number 8 after Basudev Gayan, my lord.
Yes, yes, yes. That's all?
Yes, ma'am.
My lord, I have gone through the.
My last humble submission, my lord. State, my lord, cannot now approve and reprove. When, with regard to the same selection process, state has issued pension payment order after containing a deficiency of more than 5 years in Vishwanath Dolu's case and more than 3 years, 8 months in Bongshi Bodhan Kole's case. Now here, my lord, only shortfall is
completed how
2
many
years,
years?
2 months.
You have completed how many years?
6
7
years.
years, 9 months.
7 years, 9 months, 3 days.
3 days.
There is shortfall of?
Shortfall of 2 years, 2 months, 27 days.
2 years, 2 months, 27 days. Bongshi and another name is Bongshi Bodhan and other
And Vishwanath Dolu. Sir, one
Yes.
in one perimeter year judgment, if you lordship kindly allow me, my lord, the spray worker, government spray worker only discharge service 15 months, substantive service. Before
We will
that,
not
he
take
was
that.
a temporary.
That is a different circumstances. We'll stick to the decisions of this court that has been passed in the similar recruitment process. Yes, Ms. Agarwal,
My lord,
are these petitioners similarly circumstanced as Bongshi Bodhan and Vishwanath?
my lord, the first thing is, my lord,
No, no,
the.
first answer this.
Yes. My lord, not. In my view, my lord, he was not similarly placed.
Similarly circumstanced.
Yes. Because the judgment on which my learned friend is paying reliance, my lord, the special petition, my lord, where the judgment was not interfered with, was confined to the 6 parties, my lord, who were there. And my lord, it was clearly mentioned that this benefit which has been given, it will not be cited as precedent. So it was only with regard to the parties who are appearing before the Honorable Supreme Court, my lord. Secondly, my lord, the writ petitioner is the wife of the teacher, Janara and Jana. My lord, he retired from the service in the year 2011.
Yes.
Then, my lord, after his retirement, my lord, page 70. Kindly come. कितना नंबर पेज बोले थे आप? 74. 72, sorry, my lord. On 27th of December 2011, my lord. This is with regard to the payment of pension and gratuity.
Yes.
Joiner and Jana, my lord, kindly see, certified that no provisional pension and provisional gratuity in respect of the above named teacher has been sanctioned, no dues outstanding. And my lord, thereafter the copy was forwarded to him.
Which place?
At the bottom, my lord, the copy of this was given to him on 27th of December 2011.
Page 70.
72, sorry, my lord.
Yes.
Now, my lord, thereafter, my lord, kindly see. It is the contention of my learned friend that he died in the year 2014. He received all his retirement benefits, my lord, during his lifetime. Then, my lord, present writ petition is being filed by the wife in the year 2025. Joiner and Jana, my lord, during his lifetime, my lord, did not make any claim, my lord, file any writ petition that he should be given when he was retired. He retired from the service, my lord. 2025, my lord, his wife comes, my lord, and he says that he should be given a pension, my lord. This is the present case, that he is similarly placed. He was similarly placed. But this delay of 15 years, my lord, almost, has not been explained at all.
Yes.
And my lord, after his superannuation on 20th February 2011, my lord, he died on 16 September 2014.
16 February.
16 September 2014. Paragraph 34, my lord, of the writ petition.
16 September 14. Retired on
28th February 2011.
2020.
28.
28 February
2011. Your lordship will find it at paragraph 34, page 17.
Yes.
And now, my lord, the judgment, my lord, which have been cited of my lord Justice Amrita Sinha, my lord, that was a different case altogether. There, my lord, the writ petition, the employee himself had approached the court, and then, my lord, the second point was that he had secured more than the cutoff marks.
In his case is that.
In this case, it is not the same.
In this case also the cutoff marks 34, that was not considered. and the petitioner's husband filed a writ petition along with others.
He filed the
The
writ
court
petition,
found that
the
there is
appeal
irregularity. After that, the panel was prepared and given appointment.
appointment,
So
and it is period number
circumstances
20.
is correct. The only difference here is comes that the wife is coming up.
Wife is
Not yet.
coming up, that too after 15 years, and during the of his retirement.
During his lifetime, the employee did not.
It did not sit for any this. This is the basic difference, my lord.
That is all.
So these, apart from that, my lord, so my lord, and that one point which my learned friend has argued, that the grant of pension, well, it is on the individual claim, and no third party interest accrues. My lord, citing the judgment on the ground, the court had considered that the employee, in one case, my lord, there was a delay of only 26 days. That the court has condoned, because there is a provision that the department can condone the delay of 2 years. So there was a further delay of 26 days, which the court had condoned. But in this case, my lord, your lordship will find that there was no application at all. He did not apply for it jointly. He had, in the writ petition, there was next one application which he had signed jointly, but thereafter he did not pursue his case. 2011, 12, 13 and 14 for 4 years. Thereafter, my lord, his wife also, my lord, she did not come forward. And 2025, the present writ petition has been filed. This is a case, my lord, where the court will consider the case that pension should be granted to the deceased employee who retired in 2011, did not pursue, and he accepted his retirement benefit without raising any objection. First representation was made only on 24th of September 2024 by his wife. Now, if we rely on the judgments which have been passed, particularly in the case of Vasudev Doloi, my lord, that means, my lord, as citing the precedent the court has given as an individual case, third party cannot claim benefit of that. If the petitioner would have approached, what would have been the criteria and the consideration would have been a different thing. But 4 years, the petitioner, the teacher was alive. Thereafter, his wife, 15 years, she is allowed to, 10, 11 years, no steps have been taken. And all of a sudden, 2024, it comes that he should be given the benefit without raising any claim by the husband. Whether the wife can pursue this claim of pension, my lord, this has to be considered by your lordship. Okay.
My lord. Page 73, my lord. Page 73, my lord. In the year 2012, my lord, the petitioner.
Yes, I have pointed out that. Along with several employees, it just wrote one letter and thereafter he did not
representation before the authority concerned. And with regard to Stoppel, what my learned friend has raised, my lord, I like to, my lord, cite one judgment, Asim Kumar Chakraborty, paragraph 9, 10, and 11, page 85 of the writ application. Page 85. Whether in this type of cases, Stoppel can come in. So, paragraph 8, my lord, I am reading, my lord. Page 90. Page 90, my lord. Paragraph 8 also is important. Therefore, the only question is whether the petitioner who is not at fault for not joining service and where the appointment has been arbitrarily held up by the respondents from 2002 onwards, or at the very least from February 8, 2007 till August 8, 2009, the respondents can be allowed to take advantage of their own wrong by holding that the petitioner only had around 7 years, 27 days of service left as on the date of his retirement. In that case, paragraph 9, my lord. The learned advocate for the respondents 1 to 4 has strenuously contended that from October 4, 2009 till date of the retirement, the petitioner had never raised any objection of any arbitrariness in the delay in appointing him, despite the orders of the learned tribunal, and to his entitlement to such appointment at an earlier date than as granted by the respondents. She says that the petitioner should be held to have been stopped by his inaction from August 4, 2009 till August 24, 2016 before making the first objection. So, my lord, in order to, paragraph 10, my lord, in order to test this objection, we will have to consider whether the argument on estoppel is on the basis of the law of evidence or equity. If this had been based on the law of evidence or promissory estoppel, the petitioner would have had to prove that he had acted on the representation of the respondents to his material prejudice relying only upon such representation. On the other hand, if it is an equitable estoppel, then it is a defensive doctrine preventing one party from taking unfair advantage of another when, though false language or conduct, the person to be stopped has induced another person to act in a certain way, which resulted in the other person being injured in some way. Therefore, while in the first case, the respondents have to show that they changed their position to their material prejudice by relying upon some conduct or representation of the petitioner. In the second case, the respondents have to show that they suffered an injury believing in the false language or false conduct of the petitioner, which has brought him an unfair advantage. Whichever test we employ, it is clear that the injury, if at all, has been suffered by the petitioner for having been deprived of appointment for more than 7 years after his entitlement was held in the eye of law to have crystallized, and when he was appointed, he had no other option but to accept such appointment. In this case, it was the pygmy signing on the dotted line rather than the pygmy making false allegation misleading the giant state. Paragraph 11, my lord, page 92, where therefore there is no equity in favor of the respondents, set of a defensive doctrine of estoppel, we are fortified by the judgment in the case of State of Punjab versus Nestle India Limited, and another reported in 2004, volume 6, Supreme Court cases, page 465, where their lordships have been pleased to hold that since the doctrine of promissory estoppel is an equitable doctrine, it must give way when equity so requires. In this case, the government is seeking to set up an estoppel against the petitioner on the special ground that an unemployed person litigating for employment, having won a decision in his favor after 5 years of litigation with effect from the date of filing of the original application, and after waiting for the appointment for 2 more years, should have objected to the appointment while living in penury merely to keep his claim for pension alive. We do not consider this to be an equitable conduct on behalf of the government, and even if an estoppel could have been made to operate as against the petitioner or a series of waiver, if not estoppel proper, we would choose not to enforce such an inequitable defense in favor of the respondents and against the petitioner. In fact, where the claim of the petitioner was at a lower pedestal, such as merely delay in issuance of appointment letter as a ground for rejection of the claim for pension for not completing qualifying service. The judgment in the case of Biman Bihari Thakur versus State of West Bengal and others, passed by a coordinate bench on September 2, 2019 in WPSC number 68 of 2019, Ramnagan Chowdhury versus the State of West Bengal and others passed on July 15, 2019 in WPSC number 24 of 2019 fortify us that where the appointment of the petitioner was delayed for no fault of attributable to him and where he had been favored with an appointment immediately after his selection for appointment, he would have had the qualifying service. My lord, with regard to delay, my lord, I have to cite, my lord, the paragraph 7 of the judgment of Union of India and others versus Tarsim Singh, page 76, my lord. Page paragraph 79, my lord, relevant. Page 79, my lord, paragraph 7, my lord. To summarize, normally a belated service-related claim will be rejected on the ground of delay and laches, where remedy is sought by filing a writ petition, or limitation where remedy is sought by an application to the administrative tribunal. One of the exceptions to the said rule is cases relating to continuing wrong, where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy with reference to the date on which the continuing wrong commenced. If
that's all?
No, my lord, last my lord, particularly, my lord, in the bottom, my lord, particularly in the case of pension and scale of pay, my lord, in the bottom, my lord. For example, if you lordship kindly, my lord,
For example,
if the issue relates to payment of fixation of or payment of pension, relief may be granted in spite of delay, as it does not affect the right of third parties. Which, my lord, the Honorable Justice Debabrata Chakraborty in the case of Bangshibodhan Kole, in his division bench judgment, my lord, with regard to delay and estoppel, already observed.
What is your answer to the issue that has been raised that the wife after so long has filed the application when the husband is not filing the writ petition?
My lord, it was impossible for the husband, my lord, to approach because of financial insolvency, number one. Second, my lord, physical illness. And third, my lord, no third party right has accrued for such.
That I have understood. Third party right has not accrued, but
yes,
the husband says that the husband did not come up before the court saying that
could not come, my lord, could not prefer writ application, my lord. And though file representation.
And my lord, though I have not made any lengthy submission, my lord, my written instructions are there. There are a series of judgments that have been given. I had given a copy to my learned friend. Kindly consider them. On the last occasion, I had given
judgments.
It is annexed with the instruction which I handed over. তারই তো exception নিলেন আপনি।
Exception কোথায় নিলেন?
এটা exception তো আর্গু করছেন।
না না, এই যে
So you have not annexed any judgment with your instruction?
No judgment. No judgment.
Very well, 1 minute.
May I read the relevant portion of the judgment of
my lord, আমি এটা দিইনি আপনাকে।
না আমাকে কোনো জাজমেন্ট এই দিন।
This has also not been placed with the instruction.
Then my lord, just my lord, because these are instructions which I have received, my lord, in my file yesterday only, which in my respectful submission I had given, to which he has given the instruction.
What is the date of the instruction? It is 27th August.
27th August 2025.
No, that has been filed, but she says that yesterday she has received the instruction. Then again, exception and all this will follow.
Clean the file. No, cleaning here. No, not this.
My lord,
not this one. A thick one with copy. Or shall I give him a copy?
No,
Kindly
my
keep it
lord, at
next week.
this belated
then-
stage, my lord, we have used
Then I have to-
exception, my lord. Now, my lord, at the
This
time.
report contains the some other facts in,
Yes.
because a report has
No,
been
what
filed.
I have submitted, it contains that. Because the earlier instruction, 22nd August 2025, was not given by me.
Then you could have indicated in the
My
first
lord,
instance
this was,
itself.
I had found it in my file, but I have received this instruction very recently. এটা আপনাকে দেওয়া হয়নি?
What is the date of the report?
My lord, I don't find any date.
27/8/2025.
No.
Give that.
That no date has been mentioned, my lord.
No, in this where the authority has put his or her signature, might be there is a date.
My lord, signature is there, but the date is not there. I should be very candid and clear.
Your report was filed against which the exception has been filed. Now, if you intend to place another report, then again they have to be given an opportunity to place their exception.
Certainly, my lord, I can appreciate. But I did not.
One point, my lord, delay is, my lord, dealt with by
And
the.
again, she is referring
Honorable
to some
Deputy Chief
judgment, then
Justice
again
of-
the reply has to
Yes.
be taken whether this judgment applies in this case or not.
Lord, kindly keep it day after tomorrow. I'll not try to delay the matter for this reason. I'll just take instruction from the department whether if it can be granted the pensionary benefit without giving benefit of the arrears and or interest, my lord. Let me take instruction so that it will cut short the matter. The Supreme Court
already
judgment which my learned friend has cited,
concluded, my-
2008 volume 8, in there, your lordship will find the last paragraph.
No, that is a right if not accrues in favor of any third party.
Yes.
Even if there is a delay, that delay.
They have understood the point. That is what I'm saying.
Now we are in one point that you have raised, that the wife is coming up
Yes.
after so many years.
Despite the aforesaid, my lord, if the
There was a
department
representation pending before the authority
Yes.
where the husband sought for condonation of delay.
delay,
That has not been disposed.
that has not been. No, 2012,
12,
one-
the husband has
one application has been made. Kindly see, along with others. The other had come before the court. The husband chose not to come.
The question which now comes up after the representation been made, with whether this will be construed as a continuing wrong or not.
Yes. After 12 years, 13 years.
No, that is separate aspect. Now it was on 11 he retired, and 12 he files an application seeking for condonation.
Kindly see that
12.
2012, he retired on
Along with two
28th of
brothers, he
February.
has filed an application
ওর
seeking
কত নম্বর পাতা আছে?
72.
73.
Okay, you take instruction, we come back in the coming week.
Yes, very welcome.
ঠিক আলাদা
नहीं
করে
पता
রাখবেন। হ্যাঁ, coming week. 73.
My lord,
73 it is, my lord. And my lord, all the more, my lord, these judgments have been
My lord.
passed. But what I feel, my lord, when the persons got appointment in the year 2003, my lord, they were fully aware of the fact that at the time,
No, Mr. Agarwal, all these aspects have been taken into consideration.
that was all
Tarsim
in
Singh was
each
taken
of the
into
case,
consideration.
individual cases, my lord.
The
Facts are to be
judgment of Honorable Supreme Court passed in Sum Mohan, that has also been
Mandal.
Someone Mandal, my lord, it
Yes,
says,
yes,
my lord, I've
that we
got a
have
copy of
submitted
it, my
that
lord.
should not be treated as a precedent. That has
precedent.
also been considered by Justice Sinha. Thereafter, the order has been passed, which
My lord,
may affirm.
that is why Justice Sinha had
Distinction,
considered the
what I
judgment
find the only
on
distinction
individual
is the-
basis.
Only distinction is the wife is coming up.
Yes.
Otherwise, it is 1986. Somebody has been given recruitment appointment in 2003, petitioner in 2005. Some of the pension payment orders have been issued in Bongshi Bodon, and
my lord, same selection
so
process.
they are standing. The husband stands on the same footing.
Same
Now, whether
factor.
the wife can claim such right or not, that is to be examined.
Yes.
Right.
I shall take instruction whether
instruction
this
from
representation was
becoming-
disposed of.
Or Mr. Devbroto Karan, learned advocate for the petitioner, who concludes his argument. Ms. Manju Agarwal, learned senior advocate appearing for the state respondents, also places her points of argument. However, she seeks further accommodation to take further instruction. Please this matter coming next week. একই জায়গায় থাকবে হিয়ারিং এ টাইম দিয়ে দাও 3টের সময়. So the other matters is the petitioner himself.
Yes, himself, madam.
So the argument will conclude in respect of that also.
Yes, madam.
Ms. Agarwal is appearing in the other matter.
No, madam.
No, my lord, I am not.
Which was the state?
I'm sorry.
Loknath আছে কি?
দুটো একদিনই কোর্স.
PSC is there.
On the joint prayer of the party এটা কবে যাচ্ছে?
কত নম্বর বললে?
নেক্সট উইক এর দিন.
আমি শুধু একটাতেই আছি। লোকনাথ আছে কি?
ও তো হিয়ারিং তো, তাহলে আমরা যে কোনো অন্য দিন দিন যেটা 3টের সময় হবে.
18 আছে।
মানে মানডেতে দিয়ে দিন না.
না না 17 নেই, এটা ফিক্সড ম্যাটার।
কামিং উইকে মানডে টুইসডে ওয়েডনেসডে না, মানডেতে এই ক্যাটাগরি হবে ছুটবে.
Or my lord, I shall take instruction in all the 3 matters, my lord. And
Not all, 2 matters are there.
2 matters I'll say. You indicate, I'll take instruction in all the 2 matters. Both the matters. 632 Madan
632 also.
So that both the matters can be disposed of.
কামিং
দুটোতেই
টুইসডে
নাম
কি
দিই।
আছে?
এরকম মামলা আছে তাহলে
থার্সডেতে রেখে দিন ট্রান্সফার. থার্সডে কত তারিখ দেখো? নেক্সট উইকের থার্সডেতে
দিয়ে দাও। তাহলে
এই
একটা
উইকেই থার্সডে?
যাওয়া ছড়া হয়ে যাবে।
না
আপনি আমাকে কপি দেবেন একটা written more than one
Kindly
page?
fix the time, madam.
Can you give me a copy of the writ petition?
দেওয়া আছে।
না নেই,
দেওয়া আছে।
এটা শুধু নিবা জানা আছে। আপনার ফেভারেই হবে। আমি
ওনাদের দেওয়া আছে না, মদন মোহন তুমি তো দেওয়া আছে। দেওয়া আছে
কাকে?
স্টেট রেড
330 30th July 3:30.
And my lord, if my learned friend gives me a
The joint
copy of 632, my lord,
632 on the joint prayer of the parties, list this matter on 30th July. Wait, 340.
and my lord, kindly record that in this matter, 632, my lord, I am seeking time, and let my learned friend supply me a copy of the writ petition.
supplied already. You
It
have
has been given to Mr. Singh.
Yes, to the state.
That is on, we have not been supplied.
My lord,
What
the
we-
thing says he has not been supplied.
632.
No, don't say so. We have fixed it for hearing.
Oh,
That
he is for DPSC. DPSC.
he has served copy. The petitioner has given copy. That's why it has been fixed for hearing.
If we'll make a Xerox of it,
Yes,
my lord,
yes.
at our expenses, no problem. I shall not.
That I
Leave
cannot
with the
record.
instruction.
On the
And
joint prayer of the parties, list this matter on 30th. If you have any instruction, you come up with the instruction, because the submissions will
It
almost
will
be
be identical. And I shall provide him a copy of the instructions also, which I have received from the department.
Then I have to again, my lord, file exception, my lord.
These are judgments only in 1-page note, nothing more than that.
No, this will
Judgment-
complicate the issue. We stick to the report which has been filed. If
Yes.
further instruction you intend to,
These are the only
Again,
the rules and the
again,
judgment.
my lord,
Judgment I can always cite. my lord.
Again, I have to file.
Judgment I can always
reply,
cite.
because this has not been cited by you right now.
No.
I'll give him a copy, my lord. I'll supply him a copy before.
No. Do it. If you intend to continue with your submissions, we can record your
Yes, yes.
submissions and give the copy of their
Yes,
judgment.
yes,
to it.
kindly record
Not the
that.
instruction, because
Yes,
instruction
yes.
is already on record.
Only my submission.
If you intend to rely on his judgments, give a copy to him.
Yes,
so
yes,
that he
I'll
can-
give him. I shall provide him. You give me a soft
Then, my
copy
lord,
of
kindly
the
give me opportunity, my lord, to.
Yes, you will reply to the judgment
only judgments I'll cite. I'll not give any instruction.
and take instructions.
Tasman.
Okay.
আমি আপনাকে দিয়ে দেবো কপি।
30th, huh?
Tasman.
আরে এখন আমার কাছে কপি একটাই আছে।
ওই যে দুটো আছে, স্যার।
আরে আমি আপনাকে মিথ্যে কথা কেন
Copy is not required. Give the citation at least to him. He
বলবো?
can
আছে
check
কি
it.
না? If I have, I'll give you.
Next.
My lord, regarding
No.
item number 630, my lord,
Yeah,
if your lordship directed to fix them at today, my
You
lord,
give me
appearing in the list.
একটাই আছে, আমাকে আপনাকে জেরক্স করে দিতে পারবো।
Has 630 been called?
সাইটেশনটা দিন।
My lord,
এই
item
সাইটেশন নেই, রেফারেন্স আছে, আপনি কি করে লিখবেন বলুন?
জেরক্স করে
জেরক্স করে আপনাকে দিয়ে দিচ্ছি আমি। আমি আপনাকে জেরক্স করে দিয়ে দেবো।
has been mentioned, my lord. Item number.
So 6:30, it will be in the list. It will continue in the list.
There is a direction, my lord.
What is the direction?
My lord, to submit the report
And
in
my
form
lord,
of affidavit, my lord.
6:32, my lord, my appointment be regularized by the GP.
The appointment of Miss Manju Agarwal, done at senior advocate, who usually appears on behalf of the Miss Manju Agarwal, who usually appears, done as senior advocate, who usually appears on behalf of
I'm AGP, my lord.
state
I'm additional government pleader.
and senior advocate.
Yes.
And additional government pleader. Duto rank hi diye di. Is requested to appear in this matter. Let the appearance of Miss Agarwal be regularized by the concerned authority.
Along with my juniors, my lord, I'm
Along
at
with junior Miss
Mr.
Brajendra
BP Singh and Miss Sneha Chatterjee.
Brajendra Pratap Singh.
Namta ji.
Probably on the joint prayer of the parties.
I'm appearing for the DPS Howrah in this matter. 6:32.
6:31, you are not appearing.
No, my lord. 6:32.
6:31 এ ডিপিএসসি কি ইনস্ট্রাকশন আছে নিয়ে নাও না মধু।
ঠিক আছে। হাওড়া কি? হাওড়াও নিতে পারবো।
31 হাওড়া আছে কি? জিজ্ঞাসা করো কি কারণ কি?
হ্যাঁ, ও কি বলছে? কি বলছে? 6:30 কি বলছে?
Sneha Chatterjee, Bridendra Pratap Singh and Manju Agarwal. Sneha Chatterjee.
ফার্স্ট টাইটেল দেখে নিন। হাওড়া থেকে চালান সেগুলো বলে দেবো।
দেখো।
Disturb করছে। এই তো হয় না?
3 জন। 6:31,
Provide the
6:32.
names.
ম্যাম আছে?
দুটোই একই।
কি হয়েছে?
ফার্স্ট টাইটেলটা দেখ না ভাই, এটা
কেন?
এটা ইনস্ট্রাকশন আছে।
6:31 to 6:32.
Why?
6:31 already allotted, sir.
6:31 you appeared on the last date.
6:31 I'm appearing.
There is no question of regularization. In 6:32.
6:32 only.
Yes.
Only in 6:30.
Certified copy of order sheet. Decree. What is this?
My lord, regarding
It is Howrah only.
Tanmoy Choudhury.
Madhu,
yes,
it's
my
Howrah only.
lord. Senior, my lord.
6:31 also reflected, my lord.
Mr. Jan, Madhu, নামটা দিয়ে দাও।
There is a direction, my lord. Third report, my lord, by the state in form of affidavit, my lord.
State?
Yes, my lord. The state is directed to submit the report, my lord. But the earlier order, my lord, 7/7/2026. 30. মুর্শিদাবাদ।
পরে ডাকে, কি আছে এটা? What is this matter?
Huh? My lord, it is family pension, my lord. My lord, petitioner is aged about, my lord, 95 years, my lord.
Oh. Then see?
Yes, my lord. My lord, there is a compromise title suit, my lord, regarding another lady name who is appearing in the nomination paper, and compromise degree order has been passed, my lord, and your lordship directed to give the certified copy of the order sheet, my lord. In the earlier order, my lord, we have already submitted the certified copy of the title suit, my lord. And the lordship directed the state to submit report.
Report আছে।
My lord, we are submitting.
But we have not received the report till now.
The report furnished by District Inspector of Schools Primary Education NIN. A report furnished by District Inspector of Schools, District Inspector of Schools PE Murshidabad, dated 8 July 2026 is taken on record. Copy served. Give a copy.
Yes, my lord.
My lord, I have already served.
You'll file any exception?
No, my lord. Why can't you pray for 1 week time and file the exception, man?
An advocate for the petitioner seeks accommodation. This matter after 2 weeks under the heading hearing. Under the heading hearing. Double.
My lord, can it date fix? My lord, 2 weeks দিয়ে section report report My lord, can it be fixed? My lord, date fix? My lord, 2 weeks ঠিক আছে নামটা দিচ্ছি নামটা দেখাও
I'm for the respondent of 4, my lord, for managing committee of the school.
For the petition.
কিসের পাল্টে যাচ্ছে তো 598 oh sorry
Respondent of 4, secretary of the managing committee of the
598
to status.
The will be in the matter relates to library. The same stands released from the list. All parties.
No, আমার নাম দিয়ে দিতে পারো।
The master remains also request to have a respondent to appear in the court in receive instructions.
Respondent number 4. এটা হবে না, প্রাইভেট।
This was heard. This was heard by the other bench.
Yeah. Substantially.
Then I release the matter. Let the matter go before the bench which heard it.
But now, did you change your determination, Lord? The bench taking
Since
the
this
matter.
was heard substantially by the other bench, let it go before the other bench.
Lord, it will not help our purpose because already a considerable time has elapsed in the meantime. We can submit before your lordship. It will not take much time. Everything is ready, Lord, including the written notes of argument as directed, Lord. So it will not take much time, Lord. Matter is can be cut short, and I will be very brief in my submission, Lord.
আজকে করে নিন।
হ্যাঁ, আজকে করছি।
Yes.
In this one, I am appealing for the state one. I am appealing state. I am for the private respondent.
Lord, matter relates to approval of organizing staff, Lord. He was given appointment as an assistant teacher in a school for hearing and visually impaired students, Lord, in the year 1990. The school was subsequently given approval in the year 1998. That was academic approval. And in 2006, financial approval was granted. Now, according to the rules, Lord, as circulated by the government of West Bengal, Lord, the organizing staff who is working in the post for 1 year, their name will be included in the organizing staff pattern that will be forwarded to the Director of Mass Education Extension, and accordingly, those will be approved. The petitioner was working since 1990, and up to 2004, his name was there in the staff pattern, that was forwarded to the.
When did he join?
1990.
90.
Yes.
And 2000 till 2004, his name was appearing.
Yes, Lord.
Then
his name was appearing. Subsequently, Lord, there was a change in the managing committee, and they say that 23 of the organizing staff, they left the school voluntarily, and they wanted to form another school, and for that reason, they are required to take more staffs, and thus there was a change in the staff pattern. But the staff pattern cannot be changed without the approval of the Director of Mass Education Extension. Once it is submitted for approval, not before the Mass Education Extension, the rule says it cannot be changed unless there is a prior sanction from the Director of Mass Education. I'll be placing the rules. Only two clauses in the rules will be necessary for your lordship's kind consideration, Lord, for deciding the matter. Now, Lord, when the new staff pattern was forwarded, initially when the first staff pattern was forwarded, the number was 24. I think 24 students name were forwarded. And they say that to maintain the student and staff ratio, some changes were required as some has left. And now new staff pattern, 41 name has been proposed, which was subsequently not approved. So under no circumstances, it was downsized, it was increased, expanded. And at the same time, in their affidavit, subsequently, when the matter came up before another coordinate bench, question arose whether there was any fresh inclusion in the new staff pattern. They, in their affidavit, had said, in the supplementary affidavit, that there was no fresh
Who is
inclusion.
representing Director Mass Education.
My lord, I am state. I am
State.
So they say that there was no fresh inclusion, but by comparison of the two lists will show that at least 8 to 9 new inclusions were there and 23 has been excluded, and that was completely due to political reason. I'm not coming to that much, but they were excluded. 8 to 9 names were included, and a new staff pattern was forwarded, which was approved subsequently. And the first staff pattern, which was also approved by the initially was sent and approved, that was totally given a go by without following the rules. I'll be placing the rules first, before your lordship. Then I'll take your lordship to the approval and then to the order. Initially, we challenged this matter before your lordship, before another coordinate bench, and a direction was passed for consideration by the Director of Mass Education. An order has been passed and that was rejected. My prayer was for the absorption has been rejected, against which we have come up before your lordship. Now your lordship will kindly come to page 39 of the read petition. Annexure P9. This is the rule, my lord. Norms to be followed for sponsorship, for sponsoring the institution for the handicapped. It was forwarded by the Deputy Secretary of the Government of West Bengal, Mass Education Extension Department. And this is the rule that is still followed. That is, in the year 1996, this was circulated. Your lordship will find rule number 8 at the bottom, lord. It is page 40, lord. Next page is the type copy, lord. The staff who are working for more than 1 year in the institute may be included in the staff pattern of the school proposed to be sponsored, provided the teacher-student ratio has been maintained. Next, lord, your lordship will find this is one of the most important criteria, lord. Who is working for 1 year? That is the only eligibility criteria. Nothing else, nothing more, nothing less. If he has been a organizing teacher, he was working at the time of approval and his name has been forwarded, he is qualified to be appointed, not.
But
Now,
then
next
this appointment is for any specific period, or this renewal is
it is a regular appointment.
And how your name has been removed after 2004?
That is the question we have raised, not how it can be removed when there
for 1993 to 2004, it is almost more than 1 year. So if
for
that is
removal, my lord, I'll be placing one more rule, my lord. Your lordship has correctly pointed out, my lord. My lord kindly considers no target. Lord, rule 7, clause 7, Lord. Once applied for sponsorship,
No further appointment of staff should be made by the organization. If, however, any post falls vacant after application, seeking sponsorship has been submitted, and if it is felt necessary to fill up the post, the Director of Mass Education Extension, West Bengal, to whom the application for government sponsorship has been made, should be informed of it and his clearance taken. Lord, this is very important for deciding this case, Lord.
So in the subsequent pattern, staff pattern, new names have been added,
Yes, Lord.
deleting the name of the petitioner.
23 names were deleted along with the petitioner.
And other names have been incorporated in that.
Incorporated.
Now you say that there is no clearance of the
Director of Mass Education. This point was raised. No answer has come up in the supplementary affidavit to this effect, whether clearance has been taken or not.
Without clearance, there is no sanctity or validity of that.
Of the sanction that was granted to the 41 organizing staff.
Okay.
This is my case, Lord. And now, Lord, your Lordship will kindly see the order of the Director of Mass Education Extension. This starts at page 45, Lord. And it's a P11.
Is 10584 is the earlier litigation? Earlier one? Earlier it?
Yes, Lord.
Okay. Page 45.
My Lord. And it's a P11, Lord. The issues in the writ petition I am not taking your Lordship into, because the issues I have placed is here. Can you see that his observation? And from the documents on records are noted. From the documents on record, the next page, 46. The following are noted. The Secretary of Pratibandhi Punarbasan Kendra, Kharagpur, had submitted a proposal for sponsorship of the said institution along with a staff list on 16/3/2000. My Lord, kindly note this date, not 16/3/2000. Thereafter, the Secretary of the institution submitted a fresh proposal on 28/9/2004 by the reference number S29/9/2004. Since the teacher strength in the previous proposal for sponsorship dated 16/3/2000 and 5/2000 have been considerably changed. Along with the said application for sponsorship dated 28/9/2004, a copy of the resolution of the managing committee meeting dated 9/7/2004 has been submitted. It was mentioned in the said resolution of the managing committee dated 9/7/2004 that the principal Tapan Kanti Chaudhary has resigned and he along with 20 other staff remained absent for long term, and that they had organized to set up a separate school and therefore they had no link with the Kendra. The said list of absentees include the name of Arun Kumar Ghosh at serial number 8, who is the petitioner before your Lordship. Thereafter, the sponsorship was accorded to the institution up to class 4 standard by the GO number 140 MEE Secretary dated 10th February 2006, creating 41 teaching and non-teaching posts with effect from 1/12/2005, subject to certain conditions. The conditions mentioned in the sponsorship GO dated 10th February 2009 inter alia specify the following. The existing teaching and non-teaching regular staff will be absorbed against the respective posts as sanctioned herein and will be placed in respective scales of pay in terms of memo number 553 ENMEE dated 10/4/1995, which I had placed before your Lordship earlier, Lord. The organizing staff having requisite qualification and training will be absorbed in the teaching post. No expansion in the setup, teaching, non-teaching staff should be effected without prior approval of the government. But the word used in the GO is not expansion. Not only expansion, but any change. I'll be placing the GO once again, only 2 lines. No change is permissible.
But then if the people are not attending the school as it has been recorded.
This is not correct, Lord. This is not
How-
correct because I submit before your lordship, not because these people are not. It is not correct that because there was some managing committee rivalry, a new election has taken place, not, and these people were removed because at that time it was not government sponsored, not. So anything could be done at the behest of the ruling, the majority from the majority organization, not. So the majority now they decided to remove these people who are opposing them. The new committee decided to remove them and include 8 and 9 names instead of them.
But on basis of which this observation is made that they are absentees for a long period of time.
There is nothing. That's nothing on record, not. But the cutout date, my lord, is not. At least as on 2003, name of Arun Ghosh was there, not.
It's only that the managing committee's resolution dated 9th July 2004 records that they are absentee. Is there any other documents placed on record to show that they were absentees? If they were absentees, then how they will discharge their function?
Not 2003, they were very much there. Not 2004, the managing committee has changed. Not before that.
Okay.
The 2003, his name was last appearing. I'll be placing that. They have also placed that.
Okay.
The supplementary.
Yes,
affidavit.
continue.
Now the observation, Lord. The Director of Mass Education West Bengal approved the appointment of 28 organizing staff employees of the institution with effect from 1/12/2005 by the memo dated such and such dated 10/7/2007. Name of Arun Ghosh was included in the initial proposal dated 16/3/2000 for sponsorship, but was not there in the later proposal dated 28/9/2004. So till 16/3/2000 he was there, and it was forwarded to the Director of Mass Education Extension. He himself admits that, not.
Yes.
So for sponsorship, but there was his name was not there in the later proposal dated 28/9/2004. Find the reference number S29/9/2004. The petitioner in his verbal submission before the Director of Mass Education Extension at the hearing submitted that he attended the school up to 2003. And after that, he had gone to the school but was not allowed to sign in the attendance register. Because now the committee has changed and their name has been excluded. And in the 2004, they forward a new list, excluding the name, including some other name. Next, Lord, however, your petitioner has not been able to show any documents to that effect that he has brought this particular issue to the notice of any authority. He had, at that time, there was no authority, my lord.
Okay. He had submitted prayer for absorption.
He had submitted prayer for absorption as organizing staff to the DME on 20/24/2012. The DMEE Paschim Medinipur was directed to inquire into the matter, and it was reported to the by the DMEE, that is district, on 28/12/2013 that Arun Ghosh was not working in the school as per available records. So currently he is not working. It is admitted. He was not allowed to work, and it is admitted that he is not working. But as on the date of the question here before your lordship is not whether on the date of sponsorship, when it was granted sponsorship for the first time, whether the name of Arun Ghosh was there in the staff pattern or not. Because this point has been decided in a 3-read petition, Lord, which has been filed earlier in case of different other persons of other schools not related to this particular department, where the Honorable Court has held that the date of sponsorship and financial sponsorship is the cutout date. And before that, if your name appears in the list, that cannot be changed without the permission of the Director of Mass Education Extension. Not only that, Lord, at the same time, if your name has appeared in the list,
so the committee has recourse before the Director Mass Education to approach that such and such person has not been attending if he is absent, to remove him from
so
the
that was accepted. But before appointing such person,
Yes.
clearance has to be taken. That is the rule. They straightaway appointed those persons, included their name in the staff pattern, and forwarded the same to the Director of Mass Education Extension. And the director, without considering whether clearance has been earlier taken or not, had straightaway approved the panel lot. The rule says clearance has to be taken prior to appointment. Can you see the rules once again, Lord? Page 40. 7. The type copy is next page, Lord. Once applied for sponsorship, admittedly 2000 here they have applied. Once applied for sponsorship, no further appointment of staff should be made by the organization. If, however, any post falls vacant after application seeking sponsorship has been submitted, and if it is felt necessary to be filled up to fill up the post, the Director of Mass Education Extension West Bengal, to whom the application for government sponsorship has been made, should be informed of it and his clearance taken. So without his clearance, no appointment can be made. And if there is no appointment, they cannot be included in the staff pattern. And if there is, the staff pattern cannot be forwarded to the director for approval even. These points are not at all considered. I'll be relying on those judgments of the one passed by my Lord Justice Harish Tandon, which was subsequently approved by my Lord Justice Devanshu Bosak. And detailed discussion was there by my Lord Justice Lopita Banerjee, as his lordship then was. So these are the judgments I'll be relying on. And your lordship will kindly look at a supplementary affidavit that was directed. It is on record, Lord.
Supplementary.
এটা আপনারা দিয়েছি।
January?
Yes, no. 22nd January 2025. Paragraph 4, Lord. Prior to that, paragraph 3, pursuant to the order dated 4/11/2024 of Honorable Justice Joy Sengupta, an affidavit in opposition has already been filed to the writ petition. Inadvertently, few documents, though referred to in the said affidavit in opposition, have not been annexed. The instant supplementary affidavit is being filed with a view to bring the said documents on record of the Honorable Court, as the said documents are vital and necessary for proper adjudication of the present case. The Secretary of the Kharagpur Pratibandhi Punarvasan Kendra, Kharagpur, had submitted a proposal by the letter dated 16/3/2000 for sponsorship in favor of Kharagpur Pratibandhi Punarvasan Kendra for mentally retarded and hearing impaired section of the Director of Sections to the Director of Mass Education Extension West Bengal through proper channel. In the said proposal, it was stated that the total number of students for MR section were 2000 above, 200 above, and HI section were 200 above. While submitting the said proposal, the said Kendra had submitted details of 41 numbers of staff pattern for HI section and 34 numbers of staff pattern for MR section, thus totaling 75 numbers of teaching and non-teaching staff for both MR and HI section. The name of the petitioner was at serial number 28 of the staff pattern section. Name of the petitioner was there in the 28. Photocopy has been annexed, my lord, which is annexure R2. If your lordship looks at annexure R2, my lord, that is at page 5. And lordship will find his name at
28.
Page
11.
11, my lord.
Yes.
Kumar Ghosh. Yes, not page 1128. Arun Kumar Ghosh.
28.
Now subsequently your lordship will find, but they are saying in the minutes of the meeting dated 9/7/2004 of the state Kendra, it was resolved that due to downsizing of the staff list, fresh application for sponsorship to be sent to the, it was not downsizing, not 28, and it was increased to 71. 41 has been approved. The total strength that was approved was 41. So there is no question of downsizing.
41 numbers of staff pattern for each.
Fresh application for sponsorship to be sent to the Director of Mass Education Extension. It was also stated in the minutes that
in 2000, the staff pattern of 34 numbers were in MR because this petitioner is of MR section.
Yes.
The 34 numbers it says in para 4.
Yes,
not 41. There's a 34. Now in MR section, it has been downsized to 23. Is it so? Now, what is the total now? In 2004, what is the fresh staff pattern now?
2004 staff pattern is also there, my lord.
This time the Kendriya Subject list containing 10 for HI and 15 for MR section. 9 teaching staff, 1 supporting staff.
Page 40, not page 18.
18.
The student strength has also come down, 138.
9.
Here, my lord, your lordship will find Sandeep Chakraborty, the last name.
Sandeep Chakraborty, yes.
He is the new inclusion.
It says he has resigned.
Next page, my lord. Page 19.
This is for MR.
This is for MR. Swapna Banerjee, the new inclusion. Manas Chandra, 14, is a new inclusion. Gauri Mahapatra, 15, is a new inclusion. And subsequently, my lord, at page 20, supporting staff, except Robi Pal office staff, that is serial number 5, all other are new inclusion. Complete new inclusion. Their name was not there in the previous list.
But how do they make this entry that date of joining is 1991? See, R4, Swapna Banerjee.
But their name is not there. Your lordship will find while we have checked up.
Yes, Swapna Banerjee, page number 11, Swapna Banerjee is there. First name is Swapna Banerjee. Another is Manos Chandra. Something. Manos Chandra is not there. Another is Gauri. Yes.
Gauri is not
also
there.
not there.
Total 34 was there.
Yes. 34, now you have 15. For MR section, it is 15.
But the total strength that was approved was 41. That I will be placing before your lordship.
40,
41.
no, 34.
I'm placing that.
11 is 34 of the MR section.
My lord, kindly come to the affidavit in opposition. This is the post that was approved in the year 2006. Page 14. 10th February 2006. The total strength not is at page 2 of the internal page 2. And it's a 41 strength. Joint Secretary. Approves.
Page 17.
Page 17. Mine it is not.
41 years. This 41 is approved for HI and MR both, or only MR?
Possibly, no, my lord, possibly both.
Then
segregation is there not. Possibly it includes both.
But then in supplementary affidavit, it is stated that for HI it will be 41 and for MR it is 34.
That they have stated in the supplementary, my lord. Total 75.
Then where from this they are getting?
That they will be able to explain, my lord.
Okay, the total was 41.
That is the strength.
Okay.
Not it includes both, not your lordship will
HI
take from
and
the
MR
list
both.
itself. 2 is assistant teacher HI section 8 and 3 is assistant teacher MR section 15.
Okay.
Same page, my lord.
We'll continue the next day. আজটা কাল নয়, next library date কবে আসছে?
My lord, one thing, my lord,
পড়তে থাকছে, পড়তে থাকছে, not today করে দাও, continue করে দাও। Continue করো next.
My lord, one thing.
Next we will continue.
My lord, due to change of panel, my lord, I have no affidavit opposition on reply with me. My lord, kindly direct a copy.
I will.
Opposition copy.
I will.
I also paid extension of time for filing opposition on response of 4, my lord. Secretary of the managing committee of that school, my lord.
That has already been filed.
Filed?
Yeah.
Fine.
Respond number, দেখুন তো respond number 2 এর affidavit in opposition. Yeah. You are for respond number 2.
Respond number 4, my lord. The managing committee of the school, Kharagpur, Protibandhi, Punarbasan Kendra.
Let me check up, please.
It's not filed. Because I have specific instruction that the institution has joined another school, my lord. And I have document supplied by my client.
One, two, three.
You have joined other school.
Yes.
It is not working, Lord.
The name of the school is Aid for Integration and Rehabilitation Society.
This has not been informed to you, Mr. Mukherjee.
No.
He says that he has joined other school.
That is not.
Correct. I have to file by affidavit.
Let him file his affidavit.
How then the prayer in the written petition will survive?
The read petition I have stated.
Respond number 4 was never directed to file any opposition. Huh?
So, my lord, kindly direct me
They
to
did
file
not appear
I
in
have
the
document to file on affidavit.
They did not
Sir,
appear properly.
Censor and advocate.
1, 2, and 3 has filed.
Okay. For respondent number 4, Secretary. Secretary Managing Committee. Managing Committee of Kharagpur Pratibandhi Punarbasan Kendra seeks to file affidavit in opposition. Let such opposition be filed within a period of 2 weeks. Oh. 1 week. 3 weeks for it and is for it. And learned advocate for the petition is directed to serve copy of the writ petitions as well as other pleadings to the learned advocate for the state, the respondents. Each of the
Not reply if any in the meantime.
1 week to file reply, 3 weeks. After 3 weeks, this will appear.
Yes.
Good.